I don't mention that. There are two orders passed by this honorable court, but till today they have not complied. I have filed content. This is a labor matter, Your Lordship. It was assigned to the bench of Justice Sanjay Mishra, Your Lordship. But since he was a counsel for the petitioner, so he has recused himself and the matter was referred to the Honorable Chief Justice. Now the matter has been referred to Your Lordship's bench, Your Lordship. The urgency is that the Industrial Tribunal is proceeding with the case, Your Lordship. Obliged, Your Lordship. It's a land acquisition matter and thank you, my lord.
Supplemental list, item number 1.
May it please, Your Lordship. Now, if the petitioner's land is recorded in the name of the petitioner's father, it was acquired by the opposite parties, my lord. And while the petitioner stood this, my lord, by the annexure 4 of my writ application, a clarification was sought by the additional secretary to government. He wrote a letter to all the collectors that the tractors, it will be married. Their tractors, they can be acquired with the benefits, let's say. Referring to that, I have made some representations by the annexure 5 minutes is pending before my lords. A similar matter was listed before my lords. My lords, please to pass this letter, my lords. Consider the representation.
No, this
same prayer with same
presentation has been signed by perhaps the entire villagers.
Yes, my lord. It is represented by the entire ladies, married doctors.
Petition is filed is by one. So if your particular land has been acquired, so you should file.
Everybody's land has been acquired.
No. Individually, you should file, give the details of which land has been acquired and since when, and specifically also take it down that it has not been paid. In that way, it can be not that
Sir, Sabu petitioner will say you by order culture in
No.
Is it the particular land for all?
No.
The land is different. You have not given your prayer should also be that for this particular land. I have not been given the compensation and representation should be made and some time is to be granted to the authorities to consider the same. In case they do not so, you come up. All right.
But my direct for case representation of the particular period.
The petitioner, Ganga Pradhan, has filed this writ petition for a direction to the opposite parties to consider the representations under Annexure 5 series and to provide the persons the benefits as per the provisions of Orissa Resettlement and Rehabilitation Policy 2006 within a stipulated period. On perusal of the representation under Annexure 5 series, it appears that number of persons have signed the representation and there is no specific details which land of which person has been acquired or which compensation has not been paid. Even in the writ petition also, there is no such specific averment regarding the land particulars of the petitioner and therefore we are not inclined to pass any order on this representation which is accordingly disposed of. It is up to the petitioner to file a fresh representation giving detailed particulars in accordance with law before the competent authority for consideration.
Even in the writ application of offered, the land acquired by the opposite parties under this may have payment only the lordship may direct me to file a fresh representation after the disposal of stipulated period. I will file.
You have not given the land particulars. Where have you given the land particulars?
My lord's Annexure 1.
Oh, where is the averment? And where is the prayer portion you have not mentioned?
In prayer, I have not mentioned.
That's all right. Next,
All three are same.
all right, disposed of three.
Only Prembala, the Versing will I will make a representation in
I
7
find
days.
that we have said that it is up to you to file representation. Give them some time to consider, and it's not that today you file representation, tomorrow you will approach this court for representation this court. Yes, next, item 4.
Item 4.
Where is it?
Petition one actually posed a question, who will refer the matter to the coal-bearing tribunal? And,
Our question was whether GM had the authority to refer it.
On the other day, my lord judge put that question: who is the authority to whom it would be?
I can give similar cases where GM has referred the matter.
No, not in accordance with law. Suppose
Can you read, sir?
Power of central government to direct vesting of the land or rights in a government company.
Section
Notwithstanding
11.
Section 11 of the Coal-Bearing Area Land Development Act. Notwithstanding anything contained in Section 10 of the central government may, if it is satisfied that the government company is willing to comply or has complied with such terms and conditions as the central government may think fit, to impose direct or order in writing that the land or the right in or over the land, as the case may be, shall, instead of vesting in the central government under Section 10 or continuing to vest in the government company, either on the date of publication of the declaration or on such other date as may be specified in the direction, where the right under any mining lease acquired under this act vest in a government company under subsection 1, the government company shall, on and from the date on such vesting, be deemed to have become the lessee of the state government, as if mining lease under the mineral concession rules had been granted by the state government to government company, the period thereof being the entire period of which such a lease would have been granted by the state government under those rules, and all the rights and liabilities of the central government in relation to the lease or the land covered by it shall, on and from the date of such vesting, be deemed to have become the right and liabilities of the government company. Here, the government company is the Mahanadi Coalfield Limited. The land has already vested with the Mahanadi Coalfield Limited. Under Section 17, if there will be any higher compensation payable, then it shall be payable by the government company. I will take your lordship to Section 17. The method of compensation, determination of compensation have been mentioned in Section 14 and 17, payment of compensation. May I place subsection 1 and 2 of Section 17. Any compensation payable under this act may be tendered or paid to the person interested entitled thereto, and the central government shall pay it to them unless prevented by some one or more of the contingencies mentioned in subsection 2. If the person interested entitled thereto shall not consent to receive it, or there be any dispute as to sufficiency of the amount of the compensation or the title to receive it, or the apportionment thereof, the central government shall deposit the amounts of the competent with the tribunal. Here, since the land has already been vested with the Mahanadi Coalfield Limited, which is a government company, it is the duties of the Mahanadi Coalfield Limited to pay all the liability in respect of the land.
all right, if they have not paid,
Yes.
so whether you are to direct that affected party or to directly approach the tribunal,
There is no
or
such
here,
there is no such provision under the act, or
no.
there is no rule
You have filed this representation
before
the
the
general manager Lakshman, right?
yes, ma'am.
And in section 14, it states that the central government shall constitute a tribunal,
Tribunal,
right?
right.
Number 2, then the tribunal has been given the power to determine the award,
My lord.
and which should appear to be just, and to whom it would be paid,
Payable.
and he has to due regard to the circumstance of each case, and
The
then it
tribunal
is
shall
stated that Arbitration Act will not be applicable, then the Civil Procedure Code is to be followed in respect of all these things.
My lord.
So, obviously, the tribunal is to determine all these things.
My lord.
And tribunal has been constituted in this case.
My lord.
So, you have been paid with some compensation
Some
amount,
compensation.
but you are not satisfied with
Yes,
that compensation. You claim higher one.
My lord.
So the question is here that when, like the 2013 Act, or you say that in National Highways Act,
My lord.
there is no such provision
My lord.
to refer it to the, okay,
My lord.
then, and tribunal is empowered to adjudicate, then why the party is not approaching the tribunal directly, why they will file the representation, and the representation will be forwarded to the tribunal. So when there is no such thing that it is to be, the general manager is to refer the dispute to the tribunal for adjudication. You can approach the tribunal directly. There what has happened,
My lord.
section 64 and 3G, 5 and 6, this categorically states that
Power of the
3G,
referee.
5 states about the arbitrator, and this
64
64 also
reference.
similarly, collector has to refer the dispute to the district judges. Specific provision is there. So that's a different matter. But here in this, and it does not say that those things will be applicable, whether those provisions are applicable here.
No, that is.
So that is not applicable.
That
Then
is,
how
this is
can,
special statute.
so why the party will not suppose, let us say in plain and simple, let us say against a particular you are to approach a court, let us say High Court.
My lord.
Then you there is no provision that you are to file before X, and X has to refer this to the High Court. So if that is not there, the party has to come to the High Court. It's a simple case. So those two provisions, as we have illustrated, that is totally different. That specific provision is there.
Right.
But here, since there is no provision, why are you filing the representation before the? In other cases, it might have been done, but those points might not have been raised also there. If it has been raised, answered, then that will have a precedence value. If that has not been answered, and you have to satisfy her that how we will, the tribunal will entertain such a petition on being referred by the general manager if the person directly does not approach the tribunal.
There is certain guidelines I have to accept.
Examine it, because let it be settled for all time to come.
There is some certain guidelines.
Once again, can I say that 17.2?
17.2.
17.2.
Yeah.
If the persons interested entitled thereto shall not consent to receive it, or if there be any dispute as to the sufficiency of the amount of compensation, or the title to receive it, or the apportionment thereof, the central government shall deposit the amount.
No, that is
Compensation.
the
That is
amount.
at the initial stage
That is to be
that they have
deposited.
received. But again, it says that
Differential or the interest
they have received. In some case, it may so happen that they will not agree that this amount which is
not
offered
sufficient.
to us, it's not sufficient.
That is there.
Then that is to be deposited with the tribunal.
Exactly.
Tribunal ultimately is to adjudicate the same, right? So in that case, tribunal has to issue to the parties and to adopt the procedure on the CPC, examine the witnesses, and determine what would be the actual compensation, just and fair compensation. So that is in accordance with law.
And further, under which provision you have asked it to be sent to district judge? Come CB.
17.2.
17.2. Right. Where is that? 17.2.
Section 17.2. If the person interested entitled thereto shall not consent to receive it, or thereby any dispute is as to sufficiency of the amount of the compensation, or
No, that's what he read.
Hmm?
That is what he read.
Yes.
That is to be deposited in every case.
That, my lord, what is
The moment it is deposited,
No. Where it is to be deposited? Before the tribunal. Tribunal.
Right.
That is there. But
Yes.
why district judge? You have asked.
that is the presiding Judge of the tribunal.
Where is that?
14.2.
No, but
kind of
15.2 speaks about a
Where
High Court.
no such
the judge of a High Court. Tribunal to be head by the judge of a High Court.
This honorable court
shall constitute a consisting
High
of a person who is or has or in qualified to be a judge of the High Court for the purpose of determining the amount.
Only two tribunals are constituted by this honorable court. One is at Talcher and the another at
Dhenkanal and Talcher. They are there by notification. They are there. Yes, yes. Yes, yes, that is there. That is there. That is there. Not today. That is since long. That is there. Yes, yes, that is there. That is there. That is there. Yes, sir. That is there. Notification is since long.
So,
Yes.
if that is there, then question is that whether suppose two types of case may come. One where the party does not accept the compensation,
Yes.
dispute it, right? The second case is that suppose he accepts it, but he is not satisfied, so he claims higher compensation. Okay. So in the first case, the plain and simple, it is to be deposited with the tribunal. In the second case, when he accepts it and then raises a dispute before the tribunal has to follow the procedure and issue notice to the parties and determine what would be the just and fair compensation, whether the compensation which he has received from the central government, it is correct or not, or it needs to be enhanced. So that is to be adjudicated.
To my knowledge, there is a circular issued by the central government, but I have
For reference.
that.
To refer.
That all the matter has to be referred by the government company to the tribunal. I will verify.
Verify.
And that two contingency has been taken care of in 17.2 of proviso.
No, that is
Exactly.
that is-
What fell from my lord's mouth. That two contingency has been provided in the subclause of this clause 2 of the 17.
No, even the third one, that proviso, if someone accepts in protest. So
That
it-
two
this
clause,
is all-
provided any person admitted and it to be interested for receipt. And third one is the
If that will
no
be
person who has received the amount.
If that will be decided, it will help a large number, large sections of the people.
Unnecessarily, it will be going.
Unnecessarily, they are unable to come to
Specific ଗୋଟେ gray area ରହିଯାଉଛି.
land acquisition in the state of Odisha is a very precarious condition, madam. Even in respect of Rautla steel plant, though steel plant is a heavy industry coming under these two words, but the land was acquired by the state act, not even by the central act.
You ଟିକେ input activity ପଚାରିବେ।
Is of the opinion one should directly approach. Your lordship can dispose of a large section. Probably.
For the maybe some documents or some notification, etc., might be available with the
Tribunal itself.
Right. So we are asking the register judicial to collect the information because they are dealing with such cases on day-to-day basis. So if any valuable
that will-
information
that
comes,
will-
we can.
That will help a lot of people.
Right. Definitely. The Mr. Samal and counsel appearing for the petitioner place different provisions of the coal bearing areas bracket acquisition and development bracket ends Act 1957 to answer the query that is made in the that is reflected the query that is reflected in the order dated 7/4/2025. However, after arguing for some time, we seek some further time to examine regarding availability of any notification, etc., dealing with a reference of the dispute to the tribunal constituted under section 22. 14(2) of the 1957 Act. It of further bracketry hereafter 1957. It is stated at the bar that two such tribunals are functioning in Talcher and Dhenkanal.
Dhenkanal and on
This is
Dhenkanal and Jharsuguda.
Talcher କହିଲା ମୁଁ ସେ
No, sorry.
ଆଚ୍ଛା,
Dhenkanal and
ଗୋଟେ
ଅଛି ତାଲଚେର ଆଣ୍ଡ ଝାରସୁଗୁଡା ଆଗରୁ ଢେଙ୍କାନାଳ ଯୋଉଟା ଥିଲା ସେ ଯାଉଥିଲେ କ୍ଲେମ୍ ଇଏ କୋର୍ଟ ସ୍ପେଶାଲ ଆଲାଏନ୍ସ ଥିଲା
So Talcher and Jharsuguda, yeah, stated that the functioning at Talcher and Jharsuguda. In the, it is deemed proper to call for a report from the concerned tribunals regarding the manner in which they entertain the dispute relating to the adjudication of compensation and if there is any notification or order that
with regard to the mode and manner.
with regard to the mode and manner in which such disputes are to be adjudicated and
by reference
or with relating to the reference of the dispute to the tribunal, the same are to be sent to the register judicial of this court within a week to be placed before us. File be placed before the register judicial to do the needful in intimating the aforesaid to Lion Tribunal matter to be listed as the reduction. 5th of May 2025.
Item 5.
Okay. 2 weeks time they don't do matter ଆସିବ 5 ତାରିଖ. In 2 weeks from receipt of the communication from the register judicial.
I'm fixing it to
And this is to come along with the other matter.
Other
There
matters.
are 2 matters, huh?
Item 5.
Here, my lord, it is in respect of the compensation of the Lower Indra project. In fact, the report which has been submitted by the Director RRCOM Additional Secretary was a letter dated 28th January 2025, wherein they have proceeded to the Accountant General and they have declared that decretal dues should be made to electronic transfer for proper verification and identification to the decree holder. This is the letter, and it permitted to place it.
No, the operative part of the order from which this compensation arises.
Exactly.
Paragraph number 3 is very clear that on the merits, no expression on the opinion has been given, but the court has directed the opposite party number 2. Opposite party number 2 is Director RR and ex officio Additional Secretary to Government, right?
Right.
To take a decision on the recommendation of opposite party number 5 means special land acquisition,
Special land.
and resettlement to official. So that recommendation was made on 4/1/2024. So in accordance with law, within a period of 8 weeks from the date of receipt of the copy of the order and to communicate. So he has submitted the application and
that has been duly accepted.
that is so now if whether you have taken a decision or not, that is only
Thereafter, this order on 28/1/2025 regarding sanction of the decretal amount under 28A of the Act 53,779. So in that respect, they have issued this order to make it convenient through the electronic transfer on proper verification and identification of the decree holders. This has been letter to the accountant general. So in the meantime, either they must have been received or it yes.
In portions of the order dated 19/3/2025, the Land Council for the State has placed the written instruction received from Director R&R Additional Secretary to Government. A full paragraph relevant underlying
the last paragraph. Last.
Exactly. That there has been a sanction of 53,779 towards the decretal dues under section 28 bracket capital A of the LAR in favor of and
Maji and daughter of Lakshman Maji.
Lakshman Mandi and others of village Haripur under Lower Indra Irrigation Project Khariyat Nuapada. And the payment of the decretal amount is to be made through electronic transfer on proper verification of the identity of the decree holder.
LAR case number 50 of 18. And this is LAR case number 50 of 18.
Case number in LAR case number 50 of 2018. In view of such later produced before us, this is later dated 28/2025. Copy of the content petition is disposed of. Yes. ଆପଣ ଯେ dissatisfied ହେବେ ଯିବେ ଆପଣ ଯେତିକି ସେମାନେ ଦବା କଥା ଦେଇଦେବେ
liberty you have a right
you have a right ଆପଣ ଯଦି ସେତିକିରେ ସନ୍ତୁଷ୍ଟ ନହେଲେ ଆପଣଙ୍କୁ କି ମନା କରୁନାହାନ୍ତି ଆପଣ ଯେତିକି ଆସିଲେ ସେ କୋର୍ଟ ଦେଇଦେଲେ ସେ ଆଡଜୁଡିକେଟ କରିଦେଲେ ତାପରଠୁ ତ କିଛି କୁହା ହେଇନି ନା କଣ୍ଟେଣ୍ଟ ପିଟିସନ ହଁ ଦିଟା କପି କରିଦେଇ ଦେଇଦଉନ ଗୋଟେ କୋର୍ଟରେ ରଖିଦେବେ ତାଙ୍କୁ ଗୋଟେ ଦେଇ
Item 6.
In item 6, the compliance report has been filed by the collector Katta.
Presentation of the petitioner has been disposed of on 27/3/2025. Communicated of the petitioner through the order
I've given the acknowledgement.
The Land Council for the State has produced the compliance affidavit filed by the Collector cum District Magistrate Cutter, wherein it is stated that the representation of the petitioner as per the order passed on 4/9/2023 in WPC number 268227 of 2023 has been disposed of on 27/3/2025, and it has been duly communicated to the petitioner to speak for. The huh?
28.3.
The compliance affidavit is taken on record. The content petition is disposed of.
Item 7.
Order was passed on 15/4/2025 by the Honorable Court. Thereafter, SLP was dismissed. But review is pending, not yet complied. Order dated my last order 12/3/2025. And 1 year, more than 1 year.
Just a minute. So special petition has been dismissed on 17/9/24. Right. Then the submission was made.
Review petition and filed.
That is, the submission was made by the opposite party number 2. You are appearing for opposite party number
on behalf of Mr. Haripad Mark.
See, Haripad Mark. Review petition has been filed, which is sub judice. ତେଣୁ ଆମେ କହିଥିଲୁ ଯେ you are to obtain instruction regarding the status of the review petition, which is stated to be sub judice before the Honorable Supreme Court.
It's pending before the Honorable
He has got a relief. He has got a relief from this court in the writ petition. You filed the SLP. SLP has been dismissed, and you just filed a review petition. You will not take any step for listing the same, and you will go on avoiding the implementation of the order and this content petition. There was a specific direction in the writ petition that the opposite parties number 4 and 5 are directed to extend the benefit of employment to petitioner number 1. Very specific order. Now you challenge that order in the SLP. SLP dismissed. Review petition file करूँ चुपचाप बसी वाले. एठी जल content file ना आया मैं review petition file करूँ. ता status ପାଇଁ ସମୟ ଦେଲୁ ଥରେ. ଆଉ ଏମିତି କି ନା क्या 2 ବର୍ଷ ଆହୁରି ଆପଣ ବଢି ଚାଲିବ.
Partner, today only we are filing the SOCUS matter. SOCUS affidavit in this content petition.
Content petition is SOCUS affidavit. Your writ petition has gone in his favor, the order. Your SLP has been dismissed. How contempt it so objection con file kari.
Tomorrow, day after tomorrow, my lord, Mr.
An objection con file kari. Eta content petition whether you have to, whether you have carried out or not. If you don't carry out, the consequence should follow. And if you challenge the order, you have already challenged, the result is nil. So result has gone also in his favor. So mere filing of the review petition will not do. You are to implement the order or get some order in the review petition. We cannot indefinitely keep this matter. The matter was dismissed by the Honorable Supreme Court in September 2024, and we are in April 2025.
I'm only saying day after tomorrow, day after tomorrow, Mr. Haripad Mark will act as a lordship. I don't have power in this case. He's only asked.
In spite of the order dated 17/3 as 12/3/2025, the Land Council for the opposite party number 2 has not obtained instruction regarding the status of the review petition, which is stated to be sub judice before the Honorable Supreme Court. Even the review petition number has not been provided to this court. However, the Land Council for the petitioner seeks 2 days time. Land Council for the opposite party number 2 seeks 2 days time to obtain concrete information in that respect. Put up this matter on 16th of April 2025. Yes.
Item 8.
There are 3 writ applications arises of a proceeding under the OGLS Act, my lord. Your lordship will kindly see the detailed order which your lordship has passed on 17/2/2025, directing the Learning Council for the state to produce the lease requirement.
As per your direction, madam, the lease get record has to.
So you earlier also challenged this very same order in WPC number 25647 of 2012.
Yes.
And there was a peremptory order and it was dismissed for removing the defects. How can you find another one?
My lord,
You are to,
as per
you
the
see, today, even this case also you can adopt the same method. Question is that if for removal of the defect, a writ petition has been dismissed for the, so you are to file appropriate application, comply the peremptory order, and seek for recall of that order of dismissal, and that will proceed. So second writ petition, once the first writ petition is dismissed, and the general principle is that if no liberty has been taken while withdrawing or something to file the second one, the second writ petition on the self-same cause of action will not be entertained.
That I have explained that.
Yeah.
That writ petition have been dismissed not on merit manner.
It's not.
Kindly.
Yeah.
No notice was issued.
Hmm.
Nothing has been done. It was in the threshold. It was dismissed for non-compliance of the order. This under report. Under Order 9 Rule 3, my lord,
Yes.
if a suit is dismissed for prosecution for non-compliance, it will not operate as a adjudicator. Second suit can be filed.
No, so far as writ petition is concerned, let us show the order which has been passed in that WPC number.
I have quoted in my writ petition.
Madam, in CPC, which provision is for non-prosecution? Order 11, Rule 21. Only provision for non-prosecution.
No. Just the suit dismiss Order 9 Rule 3.
Then you say that. No, there are two occasions. If you are saying that for non-prosecution, then provision is different.
It is not non-prosecution. It comes under Order 9 Rule 3. Because non-compliance of the order.
The non-prosecution or non-compliance?
Removing the defect, madam. Not removing the defect.
Non-compliance or non-prosecution?
No, non-compliance.
Is it the order?
Not removing the defect. I have quoted that order.
Where is that?
The lordship will kindly see paragraph 8, page 5.
So the CPC
dismissed it.
Yes, which provision you are saying?
I am saying
Order 9 Rule 3.
Notices are not been issued. non-prosecution ହେଲେ
No, that is under dismiss for default, what you are saying. This is not dismiss for default.
ହେଲାନି ଆଜ୍ଞା non-compliance of the order ହେଲାନି
But non-prosecution comes
ନା
under order
non-prosecution ହେଇଥିଲା
11 rule 21.
ସେଟା notice
In that case, there cannot be another second case.
ଆଜ୍ଞା
No, this provision, Order 9, Rule 3, is not applicable. That it says about after the summons are issued and the
If it-
date is fixed for
it doesn't appear.
appearance, and on that day nobody appears,
Appears.
then that is applicable. Here the notices have not been issued. Here you are asked to remove the defect at the very threshold. There are some defects for which the matter has not been taken up for admission. So the question of issuance of notice also does not arise. So at the threshold, when defects have been pointed out by the stamp reporter, the time was sought for and the time was allowed, and ultimately a specific date was given to remove the defects, and the defects have not been removed, and accordingly that has been dismissed. So in such a case, how you see that this it was a dismissal under Order 9, Rule 3, like
that is my lord if the plaint is filed and there is some deficit the plaintiff has not complied the same then suit will be dismissed
bail.
No, no. If not complied, defect
will be dismissed.
Yes.
Then second suit is maintained. I will cite decisions. Now, because that will not operate as a rejudicata. What your lordship is saying, that is the principle of rejudicata. Once it has been disposed of on merit, then second repetition is not maintainable. I have to take steps in the suit. For any reason it has been dismissed. But if in the threshold for non-compliance of the...
This is not for non-prosecution, this is for non-compliance.
Again. Therefore, it will not operate as a rejudicata.
Section 4, this Rule 4 says that about bringing of that fresh suit, or the court may restore the suit to file. So it says that where the suit is dismissed under Rule 2 and 3, the plaintiff may bring a fresh suit, or he may apply an order to set aside. So whether this Rule 2 and 3 are applicable in this particular writ petition means the factual scenario.
That has been discussed in a decision, my lord. That has been clarified that decision. That once it is dismissed on compliance of the
statutory से जो दुईटा सेक्शन जा जणा पड़छि आपन को समन्स इशू हबो डिफेंडेंट को डेट फिक्स हबो फॉर अपीयरेंस हला एवं जो दिन फिक्स अप हेइथिबो एवं समन सर्व हेइ नथिबो बिकॉज you the plaintiff fails to deposit the pay the court fee or postal charges, so that can be suit will be dismissed. That is one part. Second, if that no party appears on the date fixed, that means summons served
and neither party
appears. So that will be dismissed under Section 3. So that is the basic distinction between 2 and 3.
I am coming under 2, madam.
If you comes under 2, that means for non-payment of so and so, it is chargeable, and the failure to so and so, when a suit is dismissed so and so, the petitioner plaintiff may bring a fresh suit, or he may apply so and so. It comes to. Right, we are keeping it to tomorrow or day after tomorrow or next week? What do you want?
next week ରଖନ୍ତୁ
All right.
ମୁଁ ଆଜ୍ଞା rule 2 ରେ ଆସୁଛି
Just show some.
ଆଜ୍ଞା ଆଜ୍ଞା ତାର only principle is rejudicata
The
Rejudicata is for non-procedural.
ମାନେ only principle for that reason is rejudicata
the learned counsel, Ms. Dipali Mahapatra, a case order to 3011. As per the order dated, though the records of which was disposed of has been called for, but the same records by agent though. All right. The learned counsel for the state submits that as per the order dated 12/3/2025, he has already received the records of revision case number 737 of 1987, which was disposed of by the additional district magistrate Bhubaneswar. Stop. Ms. Dipali Mahapatra submits that though the petitioner earlier approached this court challenging the self-same order in WPC number 25647 of 2012, but the same was dismissed on 17/7/2015 for non-compliance of a peremptory order dated 9/7/2015 for removing the defects, and in view of Order 9, Rule 2, and Order 9, Rule 4, this fresh writ petition is maintainable. She wants to cite some decision in that respect, put up this matter on 15th of April 2025, along with WPC number so and so. Yes.
record ଆଜ୍ଞା ରଖିବେ
Record, the land council for the state shall keep the record to be produced on the and produce the same on the next date. Yes. 15th April. Yes. We pay to meet our WPC centers. Yes.
Item 9.
Last occasion, my lord directed statement to take instruction regarding the pending of my application, whether my application is pending or not pending. So my lord also directed me to take all the instruction to the petitions. I have asked the petitioner from the Tahsil office. They have stated that those applications.
Please wait. We have stated that there is no averment made in the writ petition when this annexure 3, which is your application, has been submitted before the opposite party number 3. So that is, you made a submission that it was submitted on 15/4/2023 before the opposite party number 3. That is the reason why we asked the Learning State Council to obtain instruction as to whether the application has been submitted before the OP3, and if so, about the status. So what is your instruction, Learning Council?
The last paragraph of the instruction.
Please.
Thus, Sri Kedar Chatoi, the petitioner, is not a homestead-less person and having a building of his wife. His application said to be filed for lease over the Chorchika Pond embankment, and its ism is Huda, Pokori Huda, is not leasable, and the vicinity to Banki Kotak Road. Hence, Sri Chatoi is not eligible for license.
Application ta upare decision nahi chal leni. How se kotha kohunandi? Not only you have, so you should have communicated the order to the why he has come. He has come to for disposal of that application. In the meantime, if you have already taken a decision, it should have been communicated so that he could have challenged the order.
2/4. On 2/4 they have disposed.
2/4. All right. Pass on that order. As per the order dated 12/3/2025, the Learning Council for the state has obtained instruction from the Tahsildar Banki that the application in form number 1, which is stated to have been filed by the petitioner, was thoroughly searched in Tahsil of his Banki, but no such application was found available, and no lease case has been registered in the year 2023 to till date, as verified from the case register. However, in the said letter, the Tahsildar Banki has stated that the petitioner is not a homesteadless person and having a building of his wife, and therefore he is not eligible for sanction of any government land. Be that as it may, since as per the instruction received from the Tahsildar, it appears that no such application as stated to have been filed under Annexure 3, it is open to the petitioner to file such application before the Tahsildar in accordance with law. Accordingly, the writ petition is disposed of.
If there is no application, on what basis they have taken this steps? If there is no application,
जेहेतु order टा गला समाने सब छानबीन करिकिन देखि देले.
if no application, then what basis?
No, we have given the order now, the copy of the order.
Exactly, I am giving the letter.
आपण जेतळे देला से आपण न देइथिले मध्ये से consider कले. Now you file the application, you will be given the hearing. आमे जा extract हला सेठी की लेखिन देइ दो. Application आपनकर तांकर खाता खतियान रे नाही. File the application and give it, send it, and then the regular procedure will be followed, and you will be heard, and whatever order is to be passed, that you can challenge in the.
That may be you will know.
The call you bra.
The copy this.
Yes, next.
Item 10.
All right.
Item 11.
11. Copy. Our copy टा दिउँ से बाहर कर दिउँ से जो order टा है हम copy टा दे.
Item 11, I have to include one party or party.
Yes, sir.
In item 11, manner, I have to include one party who is
Include a party.
You have filed an interim application or what?
You will file.
Next week, manner, I will file in the.
The land council for the petitioner submits that he intends to add some opposite party to this petition, and in that respect, she will file an interim application by next week.
Next week.
Matter be listed in the week commencing from 21st of April 2025 with the interim application, if any, filed by the petitioner.
Similar matter, manner, 18, 19, 20.
Just a minute. या सहित आसीबो 18 तापरे
19 20
19 20
21 22.
21 plus 22 भला सेम ऑर्डर चल सके.
Objection.
Item 12.
May I please file? Where is the date chart, madam? Appendix 2, madam. List of dates and events.
What is the prayer made in this petition?
Prayer may not have party agree by the order under Annexure 2 passed by the Assistant Settlement Officer by order. Rehearse the specific categorical direction of the Honorable Court under Annexure 1 to record the land in favor of the petitioner.
No, this is that Narottam Roth case.
No, madam, this is
Similar case. No? A order against a direct petition, High Court.
ADM and
no, madam. This is not one of those cases which has
No, not that case. The अपन आश्चर्य तो challenge कर जंगा A order.
No, ASO order, my lord, but over here there's subsequent development in the sense. We'll just
whatever it may be, you are challenging a particular order of the ASO against which there is other provisions in the Service Settlement Act.
But over here, my lord, may I just place the Annexure 1, the order passed by the Honorable High Court, my lord. There was an order passed by the ASO.
That has already been said. The Honorable Supreme Court has said that each individual case is to be adjudicated, and the court has to first see that whether the petitioner has exhausted the alternative remedy or not. Otherwise, the writ petition would not be entertained.
My lord, I bow down, my lord, but with great respect, this is not one of those cases, in those batch cases.
No, similar cases.
No, but similar, it's not even similar, my lord, because in the sense, ASO had passed an order.
Yes.
He has the powers, my lord. He had passed an order. That order was assailed by before this honorable court.
Yeah.
Honorable court came to a finding that he didn't have the jurisdiction to pass such an order. Honorable court remanded back the matter to the ASO, asking him to record the land in favor of the petitioner.
That has been yes. That is the spirit of order in all those cases.
No, but what has happened, my lord? The ASO comes
and
to
mutation has also been recorded basing on that.
Yes, my lord. The ASO comes to a finding that yes, it was illegally done and all.
All those orders have gone because that has been passed. Huge number of writ petition. All those orders have gone. Now, if ASO has ultimately passed the order, you have to approach the next authority in accordance with the provisions of the Service Settlement Act.
My lord, now, my lord, there is an order of this honorable court, my lord.
Yes, we know that. That order has been, but in view of the subsequent order passed by the Honorable Supreme Court, we have to follow that order.
What the ASO does, my lord, he holds that he comes to a finding that the land belongs to the petitioner and it is to be recorded in his name. But at the same time,
after the order was passed by this court, the ASO has again passed the order.
He again passed the order confirming that yes, the land is to be recorded in my name.
In all the cases, it has
all the
because the court has given direction to record it.
Yes.
And mutation has already been effected, basing on the direction.
Yes, my lord.
And that after that, this is set aside. No, after that, only Supreme Court has set aside.
My lord, I am quite aware of the Supreme Court judgment, my lord, because in those batch of cases, in two matters, I am appearing.
Yes.
But over there, my lord, the facts were different because the Honorable Apex Court came to a finding that each case has to be decided individually.
Yes, yes.
And but
so we have to first see that whether the remedy have been adjusted or not.
My lord, since there is a categorical direction of this Honorable Court, can the ASO, my lord, overreach the order of this Honorable Court and say that
you are going back, Mr. Roy, to the same thing. In those cases also, this court had given specific direction directing the ASO to prepare the record of right, and it has no jurisdiction to curtail it, and that is only set aside by the Supreme Court. So the spirit of law is
with great respect, over there.
Service Settlement. We are asking you to approach the alternative. Petitioner has filed this petition with following prayer.
May I pray for? But your lordship may kindly keep this matter to some other date because I need to examine under what circumstances those orders were passed. Thereafter, your lordship will. But over here, the factually, it's slightly different, my lord. ASO directs the Tahsildar to do the needful. The Tahsildar initiates a mutation case. And subsequently, my lord, the mutation case.
In the case of Narottam Rath so and so, it has been observed as follows: quote that Narottam Rath, in view of the order passed by the Honorable Supreme Court, since the petitioner has got alternative remedies under the Odisha Service Settlement Act, we are not inclined to entertain this petition according to this.
Your lordship may at least keep this matter to some other date. I'll just
dispose of all this type of cases which are filed. Yes, next.
Item 13.
Item 13, yes.
Alternative remedy, my lord. Let me just examine this aspect, my lord.
Yes. Examine, you can get the examine. You have already examined, and the Supreme Court has stated that this is the alternative provision. Yes, next.
Item 15.
13. May I pray, my lord, let me withdraw the petition. My lord, let me withdraw the petition to avail any remedy.
Alternative remedy at this stage. Also, Mr. Royal and Council seeks permission to withdraw the writ petition to approach the.
Avail any remedy under government.
Yes, next.
May I please, Lord? My lord, the Tahsildar Chanbali initiated a OA case in the year 1984, my lord. And in the said OA case, the land was settled in favor of the petitioner, that is annexure to running page 24, my lord. Order dated 16/2.
What you are challenging here?
Here, my lord, when the Tahsildar has already settled the land in favor of the petitioner, my lord, in the year 1989, my lord, thereafter, in the year 2023, he initiated a same proceeding, and behind the back of the petitioner, he recorded the said land in favor of the government, my lord.
No, this you are challenging annexure 5.
Annexure 5, my lord.
Come to that annexure 5.
My lord.
This has been passed by additional Tahsildar Chandbali. Chandbali na kaun ita?
My lord,
Chandbali. What is the order? Please place it into.
My lord, order dated 8/8/2023.
Yes, order ta padon.
The CR is put up to me today. Notice
annexure 5 purjandi. You are challenging annexure 5.
Page 35. Annexure 5, page 35.
35.
CR is put up.
The CR is put up to me today. Notice is served. SR back. No one is present to claim the suit land in their favor. Verified the CR and found that no proper document is present to show proper
flow of title.
Considering the same, the suit land is to be taken to the Abadajogya Anabadi Khata, subject to confirmation of the sub-collector Bhadrak. Send the CR to the sub-collector Bhadrak for confirmation. OA case number 102 of 84, dated 8/8/2023, passed by the Tahsildar Chandbali, is hereby confirmed, my lord. Thereafter, 16/7/2024, the case record is taken up to me today. The sub-collector Bhadrak is confirmed.
Has confirmed.
Has confirmed the OA case number 102 of 84, dated 30/10/2023, to transfer the said land to the Abadajogya Anabadi Khata.
So,
my lord, prior.
Who has this is a case initiated so moto or somebody filed it?
No, my lord, so moto, my lord.
So moto.
My lord.
So under which provision?
My lord, though they have mentioned the section under section 678 of OA Act, my lord, but actually they have initiated according to the government notification.
No, OA Act are
6, 7, and 8, 3 of OA.
I am coming under the 8, my lord.
8.
My lord, section.
8 ର ତ ଗୁଡାଏ ଅଛି ମାନେ
8.3. He is coming under 8.3.
8.3 ଅଛି 8 B ଏମିତି ଅଛି but you
8
କେବଳ 8 ଅଛି
continuity of tenure of tenancy.
8.3 ଟା କଣ କହୁଛି?
Any person who immediately before the date of vesting held and under an intermediary on favorable terms for personal service rendered by him to such intermediary shall, from the date of vesting, be discharged from the condition of such service, and the land may be settled with him in such manner and under such term and condition as may be prescribed, provided that nothing in subsection 3 shall apply to a trust estate which is vested in the state on or after the date of coming into the force of OA Act, Amendment Act.
Okay, so ଏଇଟା ହଉଛି ଆପଣଙ୍କର claim କଥା କହୁଛନ୍ତି
my lord.
ତାପରେ ଯୋଉ so moto power exercise କରିଛନ୍ତି
my lord,
that is under which provision?
My lord, they have mentioned in 678, that is annexure 2, page 20, my lord.
6783
କିନ୍ତୁ ଉପରେ ଲେଖା ହେଲା ଟପ୍ ଅଫ OA so moto SM ଲେଖା ହେଇଛି କିନ୍ତୁ ଅର୍ଡରିଂ ପର୍ସନାଲ ଲେଖିଲେ this is a so moto case instituted basing ବେ ବନ୍ଦୋବସ୍ତ ଖାତା for fixation of rate under section 678 subsection 3 of OA Act. Actually, it was initiated in the year 1984, my lord.
No, we are asking something else. So, suppose this is a so moto case, and the order has been passed against you,
My lord.
whether there is any alternative remedy available in that OEA Act to challenge such order, or there is no such alternative remedy for
No,
which...
before that probably you did not get it. In fact, the order which has been passed by the Tahsildar at the initial stage in 1984 ought to have been confirmed by the sub-collector. And the sub-collector, instead of confirming it, sent it back with objection.
My lord,
Before that, it is there.
My lord,
See, it is mentioned.
My lord, with
The
permission.
you see.
My
Initially also it was a suo motu case.
My lord.
It is a suo motu case instituted arising out of the HAL Bebandobasti Khata for fixation of rent. It is meant for fixation of rent, Bebandobasti, under section 6, 7 and 8.3 of the OE Act, as per the transaction of the land, as per the notification of the Land Reforms Commissioner. Issue notice. Then it comes, the Bebandobasti Khata holder is present and files Hajira. The RA is to submit his report. Then it comes to the Khata holder is absent on call. Then when it
My lord, the final order is the 24, my lord.
No.
24 is the final order.
In 1918 and 16 to 89 also it has been passed under the OE Act. Then on 28/5/2001, this case record received from Sub-Collector Bhadrak with certain objections died his letter number 845 of revenue number 28/9/2000. In the meantime, we have received a recent notification bearing Revenue Department number such and such dated 6/12/2000 regarding disposal of Bebandobast cases. According to the above notification, issue notice to the claimants. Then come 2001, 22/6/2001, then 30/5/2002. This is a suo motu case, earlier instituted, and this order has been passed. And
Lordship's permission, previously it was confirmed by the sub-collector. The OA collector settled the land in favor of the petitioner
in the year?
My lord, 89, my lord. Page 24, my lord.
Then how this...
that was confirmed.
Then how this 83, ROR is of 83? 24 January 83?
83. 89 ରେ settle ହେଲା ନାଇଁ 83 ଟା ଯୋଉଟା ଆରୁଆର ସେଟା ବେବନ୍ଦୋବସ୍ତ ସେଟା
ବେବନ୍ଦୋବସ୍ତରେ କାହା ନାଁରେ ଥିଲା?
ବେବନ୍ଦୋବସ୍ତ ଆମ ନାଁରେ ଅଛି କିନ୍ତୁ ସତ ଲେଖା ହେଲା ବେବନ୍ଦୋବସ୍ତ
ଆଉ କାହା ନାଁରେ ସେଟଲ ହେଲା?
ସେଟଲ ହେଲା ଆମ ଆନସେଷ୍ଟରଙ୍କ ନାଁରେ। ଆମ ancestorଙ୍କ ନାଁରେ settle ହେଲା। With Lordship's permission, can I place this order?
So if this order has been passed under section 6, 7 and 8, then in view of section 9, the appeal is maintainable before the Board of Revenue.
Yes, that is there. After the order of sub-collector, it is there.
My lord, my humble submission before Lordships, already the Tahsildar settled the land.
Whatever.
And the sub-collector confirmed, my lord.
All right.
Sub-collector confirmed.
So you are agreed once the land has taken back to the government khata. You are agreed by the order of the Tahsildar.
My lord, but they initiated another case, my lord, another OA case.
All right.
Surfacing the previous order, he initiated another case and issuing notice.
No, we are plain and simple. Once you are agreed, which you are challenged here, by the order dated 8/3/2023, as you say, 8/8/23, in which the land has been directed to be taken to
the Anavadi
Khata, subject to confirmation. Then, and this order has been passed under section 6, 7, 8. The question is that when a specific provision of appeal has been provided under the statute, you see, it is very clear, an appeal against any order passed by so and so, or subsection 1 of section 6 or 7 or so and so of section 8 or 8A, if preferred within the 60 days, shall lie to the Board of Revenue, who shall dispose of the appeal. So the appeal provision is there against this order.
With Lordship's permission, under which provision they initiated?
So you file it. It's the appeal. You can take up all the ground there.
Whatever grounds you are taking here, that this has been done illegally, it should not have been done, opportunity or everything.
No, my lord, my submission is that under which provision they initiated a case, because they initially initiated a
Challenge it.
Challenge it in there.
Challenge it in appeal.
Because
there is a provision for appeal.
The provision is there.
Yes.
Appeal is confined to section 3B, 5, 6, 7, 8.
8 is there, no?
8A.
Yes.
But initially he initiated a 6, 7, 8, my lord. But subsequently he initiated under which act, my lord?
So you mean to say that the authority has not given a specific provision under which it has taken, but there is a notification, as I showed you, there is a notification basing on which he has taken. Subsequently, on the basis of, first of all, a judgment of this court in OJC. OJC 1993 is the basis. Basing on which all these matters have been taken up by the direction of this court, and a notification has been issued, and subsequently these matters have been taken up. So better you, and in that case also you have to prove the flow of title. In any case, you have to prove the flow of title.
Flow of title,
So it's a disputed question of fact.
My lord, it is a disputed fact. It is a disputed fact.
Part
But
the
my
land counsel
conclusion
for
is
the petitioner
there is
and
a two
counsel for
provision.
the state.
There is a Bebandobasta circular, and there is
The
another
petition has been
section.
filed by the petitioner, so and so.
If I coming under the Bebandobasta circular, then appeal provision is to the ADM, my lord.
Yes, wherever. We are asking you to place it before the appropriate
Challenging
authority.
the order dated 8/8/2023, passed by the 8/8/2023 has been passed by Tahsildar Chandbali.
My lord.
In which it was observed that the suit land is liable to be taken to the
Abad Yogya
Anavadi Khata, right? Subject to confirmation by the sub-collector Bhadrak. The Land Council for the petitioner submits that since against the impugned order, appeal provision is there under the Odisha State Abolition Act 1951, he may be permitted to withdraw this writ petition to approach the appropriate authority. Accordingly, the writ petition is disposed of as withdrawn. Yes, next.
With Lordship's permission, my lord. With Lordship's permission, directed me to file an appeal before the member board of revenue.
No.
We are not simply stated that is.
Item 14.
Yes.
I'm Suleiman. I was detained in court number 14. While my item is over.
Item number?
10. Item number 10.
10.
Ma'am.
You can do it. Do it.
My lord, the land of the petitioner.
Your item number?
14.
14, 15, 16 sarjao tapre apan gota nabo.
In this case, the land of the petitioner was taken for the Boitrani left bank canal, and compensation was assessed under the Right to Fair Compensation and Transparency in Land Acquisition Act. But there is wrong calculations made by the special land acquisition officer regarding the quantum of the compensation.
So you are dissatisfied with the quantum?
My lord, they assessed the land value, did not take it into consideration the land value.
Well, then the question is that if you are dissatisfied, you claim higher compensation. There is provision that you are to approach a particular authority and he has to refer this matter to the.
My lord, I have filed Annexure 3.
Annexure 3
representation not necessary.
Representation. ଆପଣ ମାନେ ତା ଦେହରେ ଆପଣ ପିଟିସନ ଟାଇପ ର ଦେଇକିନି ଡାଉନ ନେବେ ଯେ କୋଉ ବେସିସ ରେ ଆପଣ କହୁଛନ୍ତି ହାୟର କମ୍ପେନସେସନ ପାଇବେ ଇଏ ରିପ୍ରେଜେଣ୍ଟେସନ ଲ୍ୟାଣ୍ଡ ଆକ୍ୱିଜିସନ ଅଫିସର କଣ କହିଦେଲେ?
No, my lord, there is wrong calculation of the compensation. wherein the land value was not
Wrong
factored.
calculation,
Minus.
apportionment, enhancement, everything is under that provision.
64 सबको कवर करूची तेणु 64 रे आपण अप्रोच करंतु appropriate application file करू दियन 2013 act of the petitioner Gauranga Charana Jena has filed this writ petition for recalculation of the land acquisition compensation of the petitioner. And for a direction to the opposite parties to pay the revised compensation along with interest to the petitioner as per the provisions of Swan Act 2013. Section 64 of 2013 Act, which deals with reference to authority, states that if any person interested who has not accepted the award may by written application to collector require that the matter be referred by the collector for determination of the authority. As the case may be, whether his objection to be the measurement of the land, comma, the amount of compensation, comma, the person to whom it is payable, and etc., including the apportionment of the compensation among the person interested. It is clear that the petitioner has not availed such remedy and he has just filed a representation before the Special Land Acquisition Officer Anandapur Barrage Project under Annexure 3. The Land Counsel for the petitioner seeks permission to withdraw this writ petition to avail the remedy as enshrined in Section 64 of the 2013 Act. Accordingly, the writ petition is disposed of. Similar thing in the other three. Okay. Yes, Mr. Purohit.
Item 10.
That was to be filed.
I prepared the data as directed by your lordship.
So have you handed over the copy to the land who is for the opposite parties?
Notice has not come.
Notice has not been. You are challenging the order of the past in the OA.
Madam. Order of the Central Administrative Tribunal is under the challenge, which is annex of page 85 to 94.
No, just a minute. These are the parties for which the State Council will appear, or they have a.
Khadi must be having a sense.
Khadi and upon appear kariye ki na kaun si? Mr. State Council. ये जो Khadi and Village Industries Commission এটা মুম্বাই এটা নয়তো
Opposite party ହେଲା private party. ଗୋଟେ ହେଲା N. Lakshminarayan Reddy and another is Central Administrative has no money. So one only
opposite parties have challenged this order. So the order has gone in favor of the
individual party.
In favor of the applicant. Who is the opposite party here? Okay. What was his prayer before the Land Tribunal?
To set aside the de novo inquiry notification matter. That has been set aside.
What is the reason has been assigned?
Only on the ground of delay, madam. No other ground. Only on the ground of delay. They have set aside the order.
So that is why we asked you to show us file the date chart.
My lord, that is how the date chart I have submitted, my lord. Memorandum of charges was given on 5/8/2010, man. He submitted the written defense on 5/10/2012, 2 years, 2 months thereafter. And subsequently, the inquiry report is submitted on 23/12/2013. There are defects in the inquiry report for which the opposite party took a view to for the de novo inquiry. But the de novo inquiry was, the decision was communicated to him on 4/4/2014. Inquiry officer was asked to submit a clear-cut report. Thus, the IU gave his finding clearly that charges against respondent are not proved, but the charged official had not followed the procedure properly while recommending the proposal from SBI Lakhanpur to SBI Belpahar. The explanation or show cause against this inquiry report was submitted by the respondent on 1/1/2015. The suspension order was revoked on 22/2/2016. And on 2/11/16, the present petitioner number 1 became the disciplinary authority by notification since the earlier authority retired. Therefore, this authority took charge of the matter and memorandum of de novo inquiry was issued. The para of the reason of the de novo inquiry is at a seriousness of misconduct accepting illegal gratification, a matter wherein the CBI has actually seized the amount. His hands had turned pink, my lord. The pink solution had become pink.
Trap case.
Trap case, he was red-handed with the presence of the decoy witnesses and everything. But still in the inquiry, it has been falsified in the department because the prosecution witnesses have not been examined, my lord. An employee apprehended by CBI trap in presence of decoy witnesses with recovery of tinted amount of 5,000 rupees with hand wash of the delinquent turning pink was observed of the allegations in departmental proceeding because the inquiry officer had not examined any of the relevant witnesses present during the
No, that order is under challenge. That is in the criminal side.
The criminal side, that is the case is going on.
That is under challenge. Oh no,
no, not under challenge.
That has not yet been completed.
No. Page 7 may be seen. The number is there. Page 7 of the petition. PR number 18 of 2010 pending in the Court of Special Judge CBI 1 Bhubaneswar. That is still pending. But in the departmental proceeding manner, they have made it false. They have shown it to
why the de novo proceeding was initiated? Where is that order? A/7 he says.
A/7.
A/7 ଦେଇଛନ୍ତି ଆପଣ? A/7, let us see that.
That is page 73.
73.
24/4/2019.
Okay.
May I place it from?
No, ଆପଣ
Para 3, 4 and 5 are the important. Page 73, para 3, 4, 5. Technical difficulty to be pointed out before this court, my lord, but I cannot give it in writing that the officials are being supported by the co-employee. That is how the prosecution takes longer time. Somebody suppresses the file, somebody says that don't stand as witness as against the person. This type of thing goes on.
So this order, annexure A by 7, as it appears, that date of draft is 24/12/2009. Then the man was suspended by later dated 11/1/2010, right?
11/1/2010, right.
Tapare
reinstated in 16 after 6 years.
Tapare apanakara taku he was charge sheeted on 5/8/2010. अच्छा inquiry जोटा आपण कले inquiry report टा dated होची 23/12/2013. That inquiry report was returned to the inquiry officer for clear cut finding. अच्छा ठीक अछि किसी charges ऊपर finding नथिला तापरे finding देले the charge framed against Sri Reddy is not true in accordance with the documentary and oral evidence. ठीक तो एवं director who is the disciplinary authority, he accepted the inquiry report.
He has not accepted the inquiry.
He
has not accepted the inquiry. He has received the inquiry. He has not accepted it now. That is the difficulty.
And
the judgment says so. My lord,
on finding
the director, the then disciplinary authority accepted the inquiry. This is wrong. This is not acceptance.
Achha.
The wording is wrong.
So this is
after acceptance, my lord, there is no need for.
Factually incorrect. Okay.
My lord.
Then representation was sought for.
My lord.
Perhaps that is the reason why you are telling that he has not accepted.
My lord.
Otherwise, there was no question of seeking for representation or reply. Tapare finding upare se reply dela 1/1/2015 रे जाटी तब देखौछि order. ସେଇଠୁ ଚୁପଚାପ ହିଁ ଆପଣ ବସିଗଲେ
ତା ସସ୍ପେନ୍ସନ ଅର୍ଡର କୁ ରିଭୋକ୍ କଲା ଗଲା sir.
हाँ, so revoke you kept month thereafter.
And
तो 2000 रिप्लाई ता पार्ट टा से सारी देला 1/1/2015 रिप्लाई से देई देला तापरे बॉल आपन को कोर्ट को चली आसला ता परे आपन कोन
4 वर्ष रहला पर
तापरे एक्चुअली सेटा पड़ी के रही कि
पड़ी के रहला पर सेया तो सेटा
सेटा 4 वर्ष पर डी नबो कहि
अल्टीमेटली आपन जेतेबेले ऑर्डर टा पास
अथॉरिटी बदली गला सर
से जाओ से अल्टीमेटली ऑर्डर टा जो पास करले सेटा होची 2019 रे ना तो फॉल्ट टा कहा पाके रहला आ ता काम से ता पई डिले लागी जो 2015 रु जेतेबेले आपन ताकू रिप्लाई मागले से रिप्लाई देई देला 2015 रु 2019 पर्यंत एक तो फाइंडिंग ता फेवर रे गला अपन ठीक अछि गोटे अथॉरिटी ताकू डिसएग्री करी किनी ता रिप्लाई मागिले से रिप्लाई देई देला रिप्लाई 2015 रे देला परे आपण को पाखु पळे आसला तो आपण चुपचाप बसी गले तापर 2019 अर्थात 4 वर्ष परे ऑर्डर कले डी नोवो इंक्वायरी so that is how the tribunal has held that the delay is attributable to you. So and he has quoted a number of decisions.
I will go to the decisions, my lord. The same decisions which my lord, the honorable tribunal has heard. I will go to the same decisions. And another decision of the Supreme Court.
The court can entertain the petition and quash the proceeding where there is no satisfactory explanation for the inordinate delay in initiating and completing the departmental तो यही प्रिंसिपल को आपण डेविएट करना ए प्रिंसिपल का एक्सेप्टेबल प्रिंसिपल दी इनऑर्डिनेट डिले हेची
कोन फैक्टर हेतला
हां
से
फैक्चुअल अवश्य प्रिंसिपल जनरल प्रिंसिपल अछि इनऑर्डिनेट डिले हेची आपण जदी सेटा को इनिशिएशन पाई बा कंप्लीशन पाई तार satisfactory explanation आसुनी then the court has power to quash the same, right?
But the gravity of the offense is to also be seen in the same judgment it is.
तेणु एठी से ऑब्जर्व करूछंती 2015 रे जेतबे इंक्वायरी कंप्लीट हेगला रिप्लाई मध्य दिया हेगला ता परठू अप टू जेतबे ऑर्डर पास के 2019 रे डीन ऑफ इंक्वायरी पाई से जो 4 वर्ष धरी आपण कोनोसी सैटिस्फैक्टरी एक्सप्लेनेशन नाही इनफैक्ट वर्तमान मध्य आपण जो देइचंती डेट चार्ट रे आपण देखै नाहंती जे ता भितरे से 4 वर्ष भितरे केमती किछि स्टे की अन्यान्य जिंस की
there is no impediment on your part
but city चलुची सीबीआई केस चलुची
then you have to wait. Why don't you wait?
I have to go slow, my lord.
No, you should have.
Then that is not the law.
Not necessary, my lord.
Case
I have to go slow is not necessary.
criminal case टा चलची बेली आपण ताल तो पूरा रही थांते चुपचाप रही
थांते कर देथांते सेटा अपे करथांते
laxity comes only when some parallel proceedings also continue, and moreover I will satisfy your lordship by virtue of the judgment circuit, the same judgment which the learned law court is like
so where it is stated that even though the delay is attributable to the department, in that case also the this should not be quashed.
No, it is not the question.
सेया तो कोण ये तो सेया जिंस ना delay is attributable to the department.
एही केस रे attributable delay या ता भी
ते केस रे मध्य आपण satisfactory explanation न देई पारले मध्य क्वास हबो नाही एंती आउट देखु ना केस रे
there is no fixed time limit for the disciplinary proceeding.
That is there.
That is the view of the Supreme Court.
But reasonability has to be seen.
So, what has taken place actually in the earlier case, even I take your lordship to the decisions, the same decisions which my tribunal has actually gone to. In the case of, say, P.V. Mahadevan, that is the decision, and another decision is N. Radhakishan.
Same, they both.
N. Radhakishan is a case, my lord, wherein I will take your lordship directly to Pada 7, 8, and 20.
You want to pass on to this one?
Madam.
पूरा पैराग्राफ कोट कर दिए 19 पैराग्राफ टा कोट करछन से
हां से 19 पैराग्राफ I take your lordship to 7, 8 and 20. 7, 18, 19, 20. Fact there, my lord. Here is a case, my lord, wherein the charges were also not proper.
So that is attributable to whom?
Department.
If the charge is also not proper.
जदि डिपार्टमेंट रो इंटेंशन नहीं ताकू प्रोसीड करिया पे प्रॉपर्ली ताले क्वास कले इट इज नॉट दैट वी हैव डिलीटेड इन फ्रेमिंग चार्जेस और एनीथिंग बट द इंक्वायरी ऑफिसर हैज एक्चुअली साइडेड विद द
that you cannot say he is your inquiry officer how can you say
आपण सी कर दला आपण निजरो इंक्वायरी ऑफिसर करले
आया से
ऑर्डर सी तांको फेवर रे देला सी साइड हे गला
सेति माय दिन माय लॉर्ड गुटे सीबीआई प्रोसीडिंग रे धदा हे जे रेगुलर 5000 टंका ता हाथ दे एग्री टू बीच देयर
ultimately it is to be proved by
my lord
so you mean to say that in every CBI case in a trap case that should result in conviction?
No, not necessarily. My your lordship has better experience than me.
No, better experience कथा नहीं आपनकर जोटा तीनटा जो necessary ingredients रहुची हला तो डिमांड एक्सेप्टेंस एंड रिकवरी तीनटा एस्पेक्ट एटा जदी आपण ठीक से सैटिस्फैक्टरी एविडेंस से प्रमाण न करी पारले तो देयर आर ही इज लाइकली टू बी एक्यूटेड तेनु वर्तमान गोटे केस ट्रायल स्टेज रे अछि हाउ कैन यू से दैट ट्रैप केस रे एमती आज्ञा तादरु color bahari gala. So khali that is that the criteria? Ja haturu bahari gala that it is to be proved that he has accepted money by making demand.
To the inquiry report, I will take your lordship. Inquiry report.
Now that inquiry report is it is going in favor of the workman. No?
Yes.
Madam.
So why
it has gone in favor of
and it should not give anything
On
which
that.
would affect or also the trial of the case. କୌଣସି ଫାଇଣ୍ଡିଂ ସେ ଇନକ୍ୱାରି ଅଫିସର ଏଗୁଡାକ ଆମର ଅଛି ସେ ତାର ଟ୍ରାଏଲ ଫେସ୍ କରିବ ଦରକାର ହେଲେ କନଭିକ୍ସନ ହବ କି ଆକ୍ୟୁଟାଲ ହବ ତାପରେ ସେ କଣ କରିବ.
We are not sitting in appeal against the inquiry.
No, madam. Why the de novo inquiry was required? That I am trying to point out. Page 63. May I take your lordship to page 63? Then we will go to the judgments.
So you say that there was defect in the charge? That there was defect in the charge according to you?
No, madam. In our case, there was no defect in the charge.
Then?
The inquiry, the witnesses did not appear. Witnesses are all government witnesses, madam. They did not.
How do you expect them to be here?
ଏଇ ଯୋଉ ଡିସିସନଟା ଆପଣ 2019 ରେ ନେଲେ 2000 ଆପଣ 15 ରେ ନେଇ ପାରିଥାନ୍ତେ ନା?
Yes.
ହଁ 15-16 ଦିନ
କଥା ତ ସେଇଠି
15-16 ଦିନ ନେଇପାରେ।
ହଁ ତାହେଲେ
that was available to me ମୁଁ ଯେତେବେଳେ ତାକୁ ମାଗିଲି ସେକେଣ୍ଡ ସୁପର ମାଗିବା
ପାଇଁ ଆପଣ କୁହାଉଛି ଆପଣ ସାଟିସ୍ଫାକ୍ଟରି ଏକ୍ସପ୍ଲାନେସନ ନାହିଁ
ତେଣୁ ତାରଟା କନସିଡର କଲା ପରେ I ought to have decided this first point that I had not done.
And even otherwise, if he is going to be convicted, you will be taking action. If he is acquitted, then they have no case. Otherwise also.
If he is acquitted, I will not have any case.
So if he is convicted, you take action.
So what prejudice has been caused to him because of my action? If he is acquitted anyway, he is reinstated in the job. He has not yet retired. The CBI proceeding is pending. The dismissal proceeding would not make his case final also. CBI proceeding would ultimately determine whether he would be dismissed or continue in the job.
So,
therefore, the delay has...
CBI case ର result କଣ ହବ ଜଣା ନାହିଁ.
Delay has not...
ସେ inquiry disciplinary authority ତାକୁ exonerate କରିସାରିଲେଣି. ତାପରେ ଆପଣ ପୁଣି ତାକୁ 6 ବର୍ଷ ପାଖାପାଖି ତାକୁ suspension କରି ରହିଲେ. ତାପରେ ପୁଣି ଗୋଟେ de novo କରିକିନି. So, and you have not explained the delay.
May I place the judgment? It is not the delay only that will count, madam. The judgment is not in the aspect of delay only. That is what I want to bring your lordship to.
No. That may be other aspect, but that is one of the ground also.
That is one of the grounds.
So,
and only on that ground it has considered. Because other grounds are there. The court has also to consider the other grounds also. Supreme Court says that other grounds are also there. That is why I wanted to point out your lordship from the Supreme Court judgment itself what the Supreme Court meant and what has been actually given effect to in this case. Now the judgment has been taken in its totality. I have given a copy of the judgment.
Who paragraph of one?
May I take your lordship to the judgment of Radhakishan, if you lordship, or P.V. Madhavan. Let me take your P.V. Madhavan.
Who paragraph of one?
Para 7 and 8. Here, the other case he also discussed. In the second case, State of Andhra Pradesh versus N. Radhakishan, the respondent was appointed as Assistant Director of Town Planning in the year 1976. A report dated 7/11/1987 was sent by the Director General Anti-Corruption Bureau, Andhra Pradesh.
এটা পুরা সে কেসর ফ্যাকচুয়াল এটা কোর্ট করছেন আধেরে কোন ultimately arrive কলে এই যে কেসরে this paragraph relates to the second case মানে যেটা আপন দউছন্তি ସେ ଜିନିଷରେ କହିଥିଲେ ତାକୁ analysis
ଏ ଦୁଇ କେସରେ ଚାର୍ଜ କୁ କ୍ୱାସ୍ କରିଛନ୍ତି ଆଜ୍ଞା ଏ ଦୁଇ କେସରେ
ଫାଇଣ୍ଡିଂ କୋଣ ଆସିଲା ମୁଁ ଏଟା ସେ କେସର ସେଇଟା କେସର ଡାଇରେକ୍ଟ ଆପଣ ପ୍ଲେସ୍ କରିବେ এই কেস রু যাই সে কেসটাକୁ প্লেস করিয়ার কোন জস্টিফিকেশন আছে
মানে এই ব্যাকগ্রাউন্ড রে এইটা দিয়া হইলা এইথিরে কোয়া হইছি যে ইট ইজ নট দি ডিলে ওনলি which is material, it is also the gravity of the charges.
A report dated 7/11/1987 was sent to the Director General Anti-Corruption Bureau, Andhra Pradesh, Hyderabad, to the Secretary to the Government, Housing, Municipal Administration and Urban Development Department, Andhra Pradesh, Hyderabad, about the irregularities and deviations and unauthorized constructions in multi-storied complexes in the twin cities of Hyderabad and Secunderabad, in collusion with municipal authority. On the basis of the report, the officials, including the respondent Radhakrishnan, the then assistant city planner, in this case, till 31/7/1995, the article of charges had not been served on the respondent. From 87 to 1995, 8 years, charges had not been submitted. The tribunal, however, heard that the memo dated 31
finding कौन जोड़ा रहे पढ़ुचंदी, you come to paragraph number 16 कौन observe कले
final conclusion कौन
आपण खाली गुटे लाइन टाको देखि देल हबो कि कौन अल्टीमेटली कौन
सेति भाई एंटायरली को नउछि
नहीं नहीं 16 नंबर पैराग्राफ टा इन एंटायरली पढन.
Under the circumstances, we are of the opinion that allowing the respondent to proceed further with the departmental proceeding at this distance of time will be very prejudicial to the appellant.
पढ़ जान.
Keeping a higher government official under charges of corruption and disputed integrity would cause unbearable mental agony and distress to the officer concerned. The protracted disciplinary inquiry against a government employee should therefore be avoided not only in the interest of the government employee but in public interest and also in the interest of inspiring confidence in the minds of the government employee. At this stage, it is necessary to draw the curtain and to put an end to the inquiry. The appellant had already suffered enough and more on account of the disciplinary proceeding. As a matter of fact, the mental agony and sufferings of the appellant due to the protracted disciplinary proceeding would be much more than the punishment for the mistakes committed by the department in the procedure. For initiating the disciplinary proceeding, the appellant should not be made to suffer. This is only in respect of the delay in the inquiry proceeding, the initiation of the inquiry and everything. And as against a higher officer, the charge was pending. May I take your lordship to the fact of the case and place it, my lord?
You have seen it. Take down. This writ petition has been filed
may I submit for
by the petitioners challenging the order dated.
May I give another new judgment, my lord?
Order dated
subsequent to that judgment, new judgment.
11/8/2022 passed by the London Central Administrative Tribunal, Cuttack Bench, Cuttack. In
this is the letter judgment of the Supreme Court.
Petition, original application filed by the opposite party, number 1, Naka Lakshmi Narayan Reddy, and passing the order dated 24/4/2019, passed by the issued by the respondent number 2, that is joint joint chief executive officer for the and Delays Industries Commission, directing for initiation of a de novo inquiry against the opposite party. From the factual scenario, it appears that the opposite party number 1 was placed under order of suspension on 11/1/2020, 11/1/2010, on the basis of information of the later dated 31/12/2009 of the superintendent. Please don't disturb us. You have completed your superintendent of police, CBI, and disciplinary proceeding as well as criminal proceeding was initiated against the applicant on the self-same facts. The respondent number 3, director for the and Village Industries Commission, issued a charge sheet by memorandum dated 3/8/2010 against the opposite party number 1, and the opposite party number 1 submitted his statement of defense on 5/10/2012. The inquiry, please
Further, I will not go to the merit of the case, my lord. I will go just two judgment.
We will not hear you. The inquiry report dated 23/12/2013 has been submitted, and thereafter the inquiry officer was asked to submit a final clear-cut report, and in response to that, the inquiry officer, by later dated 4/4/2014, informed that the charges framed against the opposite party number 1 are not proved. The it is the case of the opposite party number 1 that the disciplinary authority accepted the inquiry report, and it was forwarded to the to him for his reply, and accordingly he submitted the reply, and thereafter the opposite party number 1 was reinstated by later dated 22/2/2016 after revoking the order of suspension. But it was ordered that the period of suspension will be decided after considering the outcome of the court cases filed against the opposite party number 1. The opposite party number 1 thereafter while the matter stood thus, the respondent number 2, Joint Chief Executive Officer, by memorandum dated 24/4/2019, decided to initiate de novo inquiry against the opposite party number 1, which was the subject matter of challenge before the Land and Central Administrative Tribunal in OA number 424 of 2019. The respondents, the petitioners of this writ petition filed the counter affidavit, wherein it is stated specifically that the inquiry report was never accepted by the disciplinary authority, but one copy was sent to the applicant in view of the provisions contained under the regulation 11(2) of KVIC CCA regulations 2003. The respondents, the petitioner's case was further that the disciplinary proceeding initiated against the opposite party number 1 was never concluded, and no final order either punishing him or exonerating him was issued. And the disciplinary authority kept the matter pending for final decision and retired after attaining the age of superannuation, and then the inquiry report was placed before the respondent number 2, who, after carefully perusing the report of the inquiring officer, found that the inquiring officer has not made detailed analysis of the statement given by the prosecution witnesses before coming to the conclusion that the charges are not. Accordingly, the impugned order dated 24/4/2019 was passed, initiating de novo inquiry against the applicant. against the opposite party, number one. The London Central Administrative Tribunal took into account the factual scenario and also the ratio let down in the case of state of Andhra Pradesh versus N. Radhakrishnan, reported in 1998 for SCC 154, and came to hold. So also the ratio let down in the case of PV Mahadevan versus MD TN Housing Board, reported in 2005, 6 SCC 636, and came to hold as follows. Quote the entire paragraph number 14. Mr. Purohit, London Council, appearing for the petitioners as per the order dated 4/4/2025, placed the date chart before us. And he also placed the citations which are being relied upon by the London Central Administrative Tribunal.
Cited another decision.
Pass on that decision. In the PB Mahadevan versus MD Swanstone,
I have declared on.
It is held as follows. Quote paragraph number 16. It is Chinna Maraj. In Radha Krishnan, the Honorable Supreme Court has held as follows. Quote paragraph number 19. Mr. Purohit placed reliance on the decision of the Supreme Court in case of Government of AP Andhra Pradesh versus B. Appala Swamy, reported in 2007, bracket 14 SCC, page 49, wherein it is held as follows. Quote paragraph number 10. So, in the case in hand, as it appears that the criminal proceeding which was initiated against the opposite party, number one, is sub judice before the competent court for trial. It appears that the after the disciplinary authority perused the inquiry report, it was found that the inquiring authority after examining 4 witnesses, submitted the report with no clear-cut finding, for which he was asked to resubmit with the clear-cut report, and accordingly, the inquiry officer submitted the report that the charges against the opposite party number 1 are not proved. Which was not accepted by the disciplinary authority, for which a reply was sought for, and the petitioner seems to have submitted his reply. The opposite party number 1 submitted his explanation oblique show cause on 1/1/2015. No decision was taken immediately thereafter. The petitioner order of suspension was revoked in 2016, and on 24/4/2019, the decision has been taken by the respondent number 2 for de novo inquiry. On the basis of the factual scenario, it is apparent that there was no laches on the part of the opposite party number 1 and the disciplinary authority kept the matter pending, and ultimately, after more than 4 years after filing the explanation oblique show cause, the order dated 24/4/2019 was passed for de novo inquiry. The Honorable Supreme Court has categorically stated in V. Appalaswamy case that the question of delay in concluding the departmental proceeding against a delinquent officer is to be determined on its own facts, and where the delay has caused prejudice to the employee, or by reasons of the delay, the employer condoned the lapses on the part of the employee, the proceeding can be directed to be quashed. In the case of N. Radhakrishnan, it is specifically stated that if the delay is unexplained, prejudice to the delinquent employee, unexplained, prejudice to the delinquent employee is writ large on the face of it.
The fact is different.
It is the basic principle of administrative justice that an officer entrusted with a particular job has to perform his duties honestly, efficiently, and in accordance with rules. If he deviates from the path, he is to suffer a penalty prescribed. Disciplinary proceedings should be allowed to take its course as per the relevant rules, but then delay defeats justice. Delay causes prejudice to the charged officer unless it can be shown that he is to blame for the delay, or when there is proper explanation for delay in conducting the disciplinary proceeding. And the court is to balance these two diverse considerations. On the face of it, we find that the petitioner, the opposite party number one, cannot be blamed for the delay. And the explanation which has been offered that one officer has retired and another officer came, in our humble view, cannot be accepted as a proper explanation for the delay in taking the decision of de novo inquiry. After going through the impugned order, the citations placed by the London Council for the petitioners, the date chart, and the short note, we are of the view that there is no illegality or infirmity in the impugned order. Therefore, this writ petition being devoid of merit stands dismissed. Yes, next.
Item 17.
Is item 17?
17, my lord.
Yeah.
And next, 3, my lord, are already submitted before government for sanction of the amount.
Judgment has been passed by the award has been passed by the LA collector.
By the referral court.
Referral court.
My lord. Answer 2.
In LR case 21.
LR case.
Then
21 by 9. Then thereafter, LO special LO was directed to pay the enhanced compensation within 4 months.
So, what is the status of this letter dated annexure 9/8/2024? Get the instruction about it. Huh? This writ petition has been filed by the petitioner S.K.Sahoo with a prayer for a direction to the opposite party number one, Commissioner cum Principal Secretary to Government of Odisha, Water Resources Department, and that is opposite party number one, and Director R&R cum Additional Secretary to Government of Odisha, Water Resources Department, opposite party number 2, to sanction and disburse the awarded amount in favor of the petitioner for acquisition of his land for construction of Lower Indra irrigation project as per the judgment and order dated 20/2/2024 passed by the Land Civil Judge Senior Division Wapada in LAR number 21 of 2019 within a stipulated time. The Land Council for the petitioner placed annexure 3, which is the letter dated 9/8/2024 issued by the special LA and so opposite party number 3 to the director R&R opposite party number 2. Wherein a request has been made that the decretal award amount to be sanctioned to expedite the payment to the decree holder. Let the Land and Council for the state obtain the status of this application under Annexure 3. Put up this matter. Kete samay darkar? Now, the Land and Council for the petitioner shall also obtain instruction as to whether any execution case has been filed.
No,
or
I have obtained instruction. No,
just file पर we are writing file with memo जहाँ दबा कर दे दें है ना or executing the order dated one है ना बाकी so can it be done on 2 weeks ଆପଣ 5 तारीख ଦଉଛୁ ହେଲା ତ order ଟା pass ହେଲାଣି 20/2/2024 ଆପଣଙ୍କର ଗୋଟେ ଅଥରିଟି ଆଉ ଗୋଟେ ଅଥରିଟି କୁ ଚିଠି ଲେଖୁଛନ୍ତି 9/8/2024 ତ ୟା ଭିତରେ ଆପଣଙ୍କର 8 ମାସ ପୁରୀ ଗଲାଣି ଲୋକଟା ଫେଭରରେ ଅର୍ଡରଟା ହେଇଛି ପଇସାଟା ପାଉନି ଜମିଟା ଆପଣ ନେଇଯାଇଛନ୍ତି ଆକ୍ୱିଜିସନ କରିଛନ୍ତି ତ give him that order should be passed na so issues just କାଇଁ delay କରୁଛନ୍ତି ଏସବୁ ମ୍ୟାଟର 5 ତାରିଖ ରଖିଦେବେ 5/5/2025 yes
Item 23.
Mr. Behra, next matter document.
23.
23 your matter.
Yes, sir.
The other matters have been, so that is why your matter was called.
Yes, sir.
What is this matter?
Challenging here the rejection of my application under section 28A application under annex 5 running page 25.
Elect.
Annex 5 running page 25. Here my application under section 28A of the Land Action Act has been rejected. Last paragraph was.
तापरे किसी रिपोर्ट कौन अच्छी देखी लैंड एक्विजिशन एक्ट रे 28 एप्लीकेशन अपन को रिजेक्ट हेले देख कोई
सेटा रिजेक्टेड इलीगल
अरे तापे अथॉरिटी अछि ना डायरेक्ट
नहीं
Madam, have you verified the provisions against 28A Land Acquisition Act पढ़िछंती देखुन
The funds has not been made by the petition. Not
Section 8.
Has not never applied for the they received the award on the protest. The records is not
28A रे पूरा कलेक्टर तक को कलेनी Redetermination ହେଲା?
What about this provision under section 54?
Is not gone for the LA court. Yes.
The
Redetermination is LA court को जो हाँ.
ground of rejection or kind of
ground
No, that is there.
सियाड़ू जाइनु आमे we are on a जे
Point of law रे
हाँ
कौन
point of law रे आमे अच्छे तो ground of question is जो point अपन raise करचंती जरा appellate authority थी वो you can raise that point को से इतने देखियो चाहूँ चु जे whether this is an available or revisable order or not. So that is why if alternative remedy is available to you, then ये भी गोटे कहिसेंती जे the petitioner has submitted the petition under section 28A on the strength of the judgment dated 10 to 2023, which was disposed of by the London Senior Civil Judge Nuapada. Estimate in the referred LAR number so and so has been submitted for sanction to the Department of Water Resources by so and so. The same has not been sanctioned till date. Since the sanction in referred LAR has not been accorded, the petition under section so and so cannot be disposed of at the present. So you are not a party to that LAR case, right? So after the order was passed, you filed this petition under section 28A. So 28A says about the redetermination of the amount of compensation.
Already estimated has been made and submitted before the government.
Wait. Just a minute.
In the meantime, sanction has been.
Who were party for the LA under section 18? WPC totally. What is the order of the civil court?
Civil court को annex करने आमे सेट को refer करके application 28 application.
नहीं जी 8 फाइल नकल आमे केम जानिबो
कौन है जीता
That is very important. You file the order, copy of the order.
Yes, sir.
You file the copy of the order. We'll see out of it.
LAR case number 180.
Yes, sir.
This petition has been filed challenging the order dated 26/4/2024 of the special LA and so lower Indra Irrigation Project, Karya, in which the petition filed by the petitioner under Section 28A of the LA Act 1894
on the strength of
has been rejected. It appears that such a petition was filed on the strength of the judgment and order dated 10/2/2023 passed by the Learned Senior Civil Judge Nuapada in LAR case number 183 of 2010. But the Learned Counsel for the petitioner has not filed the copy of the said order.
judgment dated
10/2/2023. Learned Counsel for the petitioner seeks some time to produce such document, certified copy of such document, put up this matter. The Learned Counsel for the state also seeks time to examine as to whether against any order passed under Section 28A of the LA Act 1894, if there is any alternative remedy to challenge the same or not. Put up this matter.
In the meantime, estimate has been made under Annexure 6.
We'll see.
Judgment आगे दियो तो केबे देबे कोन तो हमें रखी देबा certified copy देबे. Put up this matter on recommencing from 21st April 2020.
Item 24.
କୋଉଟା କହି ଦିଅନ୍ତୁ ଏକା ଭଳିଆ ଯଦି
23, 25. 25, 27.
ନାଇଁ 25 ଟା ଆପଣ କରନ୍ତୁ
26 ଅଛି
26.
26, 27 and 28.
28.
Similar matter.
Similar.
अच्छा ता धीरे
30 भी ସେଇଟା
अच्छा ये जो केस रे ता धीरे कौन से समान ये ना
सेम एलआर
जस्ट खाली ଟିକେ चेक कर देबे एलआर केस नंबर टा कोर्ट ना और डेट टा
गोटे एलआर केस 1 विलेज
समान थियो
ଗୋଟେ ତ
आगे
ता धीरे आउ किछि लिखिबा दरकार नै ए जो 26, 27, 28 रे it will come along with item number 20 हैला ठीक है yes
Item 24.
yes Mr. Mishra.
My lord, kindly see annexure 3 Millard at page 27. My plot number 2943 has been acquired for the purpose of Talcher Bimalgad railway project Millard. My lord, this is father under annexure 2 has purchased the Shootland Millard. 13 decimal my father has purchased. I am
where is the documentary proof that you have been your land has been acquired and you have been then you must have been also noticed for that purpose.
My lord.
So notice again upon quite
annexure 3. My lord, annexure 3 at page 27 your lordship may can see they have called me for the receiving of compensation. ଏତ ଦ୍ୱାରା notice ଦିଆଯାଉଛି ଯେ ଉପରୋକ୍ତ ମାମଲାରେ ଆପଣ କେସ୍ ସ୍ୱାର୍ଥଯୁକ୍ତ ବୋଲି ବିବେଚିତ ହୋଇଥିବାରୁ 2013 ର ଅଧିନିୟମ ଅନୁଯାୟୀ 30/9/2021 ରେ ଏକ ଅଧିନିୟମ କରାଯାଇଥିଲା ତଦନୁସାରେ ଆପଣଙ୍କୁ 1,18,00,000
ନାଇଁ ଏ କୋଉଠି ନା ଲେଖା ହେଇଛି କୋଉଠି ଏଟା ପିଟିସନର ଇସ୍ୟୁ ହେଇଛି ବୋଲି
ସେଇଥିରେ ମୋ ପ୍ଲଟ ଅଛି ବା
କୋଉଟା ଆପଣ କୋଉ ପ୍ଲଟ ଟା କହୁନା
2923
2923
ଏଇ ଯୋଉଟା ଅଛି
18 ଡିସିମିଲ୍
ଆଚ୍ଛା 2923 18 ଡିସିମିଲ୍ ହଁ ସେଠୁ
ସେଥିରେ ମୁଁ କିଣିଥିଲି 13 ଡିସିମିଲ୍
ଠିକ ଅଛି
ନୋଟିସ ହେଇଥିଲା 18/10/2022 ରେ
ହଁ ତାପରେ
କିନ୍ତୁ ଏପର୍ଯ୍ୟନ୍ତ ପେମେଣ୍ଟ ଦଉନାହାନ୍ତି ଖାଲି ଆଜି ଆସ କାଲି
ନାଇଁ ଆପଣଙ୍କୁ କୁହାଲା ପରେ ଏଇ ଡକ୍ୟୁମେଣ୍ଟ ଗୁଡା ଦବା ପାଇଁ
ଡକ୍ୟୁମେଣ୍ଟ ସବୁ ମୁଁ ଡିପୋଜିଟ କରିଛି
କେବେ ଦେଲେ ତାର ପ୍ରୁଫ ପାଇଁ
My lord, document my client has produced his document, my lord.
ଆପଣ ଯୋଉ annexure 4 ଟି ଦେଇଛନ୍ତି ରିପ୍ରେଜେଣ୍ଟେସନ ରେ କିଛି ଲେଖି ନାହାନ୍ତି ଯେ ସେ ଖାଲି ଲେଖିଛନ୍ତି ଯେ land acquisition officer issued notice to receive the compensation amount but that was subject to filing of the documents. You have not mentioned that you have submitted the documents before the authority.
My lord, it is a fact that my client has deposited the document.
अरे आपण ଆପଣଙ୍କର କହିବା କଥା ଯେ ଏଇ ଯୋଉ ଡକୁମେଣ୍ଟ ଦେଇଛନ୍ତି ବୋଲି ଆପଣଙ୍କ ରିପ୍ରେଜେଣ୍ଟେସନ ରେ ନାହିଁ, ଆପଣଙ୍କ ରିଟ୍ ପିଟିସନ ରେ ଆଭରମେଣ୍ଟ ଅଛି।
My lord,
ଯୋଉ ନୋଟିସ ଟା ୟୁଜ ପଠେଇଲେ ଆପଣଙ୍କୁ ସେ ନୋଟିସ ରେ ଆପଣଙ୍କୁ ଏଇ ଡକୁମେଣ୍ଟ ଖତିଆନ ସେ ଭୋଟର ପରିଚୟ ପତ୍ର ଏଇ ସବୁ ଜିନିଷ ଏ ସବୁ କହିଥିଲା ଆଣିକିରି ବ୍ୟାଙ୍କ ପାସବୁକ୍ ଏଗୁଡା ସବୁ ଦବା ପାଇଁ। ତ କୋଉଠି ଆପଣ ଆଭରମେଣ୍ଟ ନେଇଛନ୍ତି ଯେ ଇନ ପର୍ସୁଆନ୍ସ ଅଫ such notice you deposited the required documents and if so on which date, because no such averment has been taken in the representation which you filed on 1/11/2020.
that due to the inaction of the opposite party
inaction କଣ ଆଉ ସିନା ଡକୁମେଣ୍ଟ ଦେଲେ ତାପରେ ଇନାକ୍ସନ ଆସିବ। ଆପଣ ଯଦି ଡକୁମେଣ୍ଟ ନ ଦେବେ ଏଇଟା ହଉଛି ଆପଣଙ୍କର ଇନାକ୍ସନ ଆସିବ, ତାଙ୍କର କଣ ଇନାକ୍ସନ?
My lord, your lordship may kindly add that again I will file the required document before the authority. OP number 3 and
There
4.
is nothing in the writ.
My lord, they will raise the
Mr. One more thing is also here. In the notice, it is only the plot number, and you say that you have purchased that land. A portion of that land has been purchased by you.
Purchased by me.
Are you sure that your landowner has not taken it?
No,
because
my
name is not there.
My lord, landowner has not.
Your name has already been mutated.
My lord, I have.
Your ROR is already in your name. ROR.
ସେଇ ଜମିଟା ଯଦି
ହେଇଯାଇଛି ଆପଣ ନାଁରେ, ତାହେଲେ ଓନର ନେଇଯାଇଥିବ।
ଓନର ନେଇଯାଇଥିବ, ଆପଣ ROR ଧରି ବସିଥାନ୍ତୁ, ସେ ତାର ସେ ଖତିଆନ ବଳରେ ସେ ନେଇଯାଇଥିବ ଟଙ୍କା, ଯାହା ନାଁରେ ଜମି ଅଛି ତାକୁ ଦେଇଦେବେ ନା।
My lord, annexure 1 is the Khatian. It is in the name of Panu Kisan.
ଆଉ ତାହେଲେ
ସିଏ ତାର ଦେଖେଇଦବ,
ସେମାନେ ସବୁ ଦେଖେଇକି ନେଇ ସାରିଥିବେଣି।
ଆପଣଙ୍କ ଡ୍ୟୁଟି ହଉଛି ଯଦି ଜମିଟା ପାଇଲେ ରେଜିଷ୍ଟର ସେଲ୍ ଡିଡ୍ ରେ, ତାହେଲେ ମ୍ୟୁଟେସନ ପ୍ରୋସିଡିଂ କୁ ନ ଯାଇ ଚୁପଚାପ ବସିଗଲେ। ବର୍ତ୍ତମାନ ଆପଣ କ୍ଲେମ କରିବେ ଆପଣଙ୍କର ଯିଏ ଇଏଠୁ
ଯିଏ ନେଇଥିବେ ତାଠୁ ଆପଣ କ୍ଲେମ କରନ୍ତୁ, ଦ୍ୟାଟ ଇଜ ଡିଫରେଣ୍ଟ। ଆପଣ ତ ଆପଣ ନାଁରେ ROR ନାହିଁ, ଆପଣ ଏବେ କହିଲେ
ହଁ ଅଛି ନା,
କାଇଁ
ଦେଖୁନା
କାଇଁ
କବଲାଟା ଅଛି ମ
ସେମାନେ ତ ROR ଦେଖିକି ଦେଇ ଦେଇଥିବେଣି।
ସିଏ ଆପଣଙ୍କ ଭଳି 5 ଜଣଙ୍କୁ ଆଉ ବିକି ଦେଇଥିବ, ବିକି ଦେଇକିନି ସବୁତକ ଟଙ୍କା ଆପଣଙ୍କ ମାନଙ୍କଠୁ ନେଲା, ପ୍ଲସ କ୍ଷତିପୂରଣ ଟଙ୍କା ସରକାରଙ୍କୁ ଧରିଲା, ଚୁପଚାପ ବସିଲା, ବୁଝିଲେ?
My lord, that after the death of Panu Kisan, as his son Braja Kisan sold plot number ଏତେ।
ଓ ଆପଣ ତା ପୁଅ ପୁଣି ବିକ୍ରି କରିଛି?
ହଁ,
ତାହେଲେ ଆହୁରି
13 decimal to one Jana Kisan, who is the father of the present petitioner.
ଆପଣ ବୁଝନ୍ତୁ ଏସବୁ ଜିନିଷ, ବୁଝିକିନି ଆଉ ଥରେ ଯଦି କେସ୍ କରିବା କଥା ଆପଣ ତା ନାଁରେ କେସ୍ କରନ୍ତୁ, ଆପଣଙ୍କ ଜମି ବିକିନି।
Para 3, my lord, your lordship may kindly see para 3. That after the death of Panu Kisan name is the ROR.
We will say dispose of that. There is no evidence, no material before us that you have submitted the required documents, and moreover the land has not been mutated. आउरी भितरु गले आउरी असुविधा हो, तेणु बेटर होची विड्रॉ कर नियंतु, सियाडे देखंतु पैसा पत्र अछि ना से नै पळेलाणी, आउ
हेले अन्य प्रोविजन रे आपण पुनी क्लेम करिवे 64 रे क्लेम करिवे।
My lord, your lordship may kindly see that I will file a fresh representation, let them reply to why they have not paid. So thereafter I will challenge if I will not be satisfied.
Compensation जदि payment न हेई थिबो ए पर्यंत एवं what has been pointed out 64 रे आपण रिपोर्ट्स नहीं परिबे जे you are entitled to
apportionment
में आपनकर रहिबा दरकार।
My lord, your lordship may kindly take instruction my lord in the matter. They will give a counter my lord, so
why it is your case,
document दिया ही नहीं, ସେମାନେ instruction ନେଲେ କଣ କରିବେ?
ଆପଣଙ୍କର it is your case,
ମୁଁ fresh representation ଦେବି, fresh representation ଦଉ,
ତାହେଲେ
withdraw करते हो। The writ has been filed for such and such date. Mr. Mishra and counsel for the petitioner seeks permission to withdraw this writ petition to file to seek appropriate remedy in accordance with law in the charter. Yes.
My lord, liberty to file a fresh representation.
आपण पहले जहा रिमेडी अछि रिप्रेजेंटेशन अन्य जो प्रोविजन रिप्रेजेंटेशन नेबो 64 को हमें किछि कहिबुनी, ଯଦି 64 ରେ ଆପଣ
ଆସୁଥିବେ
ଆସୁଥିବେ ଆପଣ ସେଇଟାକୁ ନେବେ। ଆପଣ ଏଠି ଯଦି ରିପ୍ରେଜେଣ୍ଟେସନ ରେ ଇଏ ହେଇଯିବେ ଆପଣ ସଂକୁଚିତ ହେଇଯିବେ, ବୁଝିପାରୁଛନ୍ତି ତ? So if you think that appropriate application can be filed under section 64, avail that remedy, है ना? Alternative remedy ଯଦି ଅଛି ଆପଣ avail କରନ୍ତୁ। Yes. Next.
Item 25.
My lord, this is a land acquisition matter. The collector Jaspur made a notification for acquiring the petitioner's land for expanding and strengthening the road and directing the villagers to file an objection, if any, within 16 days, 60 days. That is Annexure 3, page 35. Lordship, kindly see the paragraph 4. जदि संपृक्त जमीर कौनसी स्वतःधिकारी जमी मालिक भूमि अधिग्रहण अधिसूचना संपर्कित अधिसूचित जमीर उपयोगिता रकबा और सर्वजनीन उद्देश्य उचित विषय कौन आपत्ति थाए से उक्त प्रारंभिक अधिसूचित प्रकाशन 60 दिन मध्य संपृक्त जिलापाल निकट में लिखित आकार अभियोग जनाबे। That notification was issued on 9/11/2023. And according to that notification, the petitioners made an objection within 60 days, that is Annexure 4, my lord. And they received it. And they have endorsed, that is
received, yes.
My lord. The collector, without considering that objection according to section 15 of new Land Acquisition Act 2013, he issued a notification under section 19 with lordship's permission, my lord. That is according to section 15, my lord.
Annexure 5.
My lord. Annexure 5, that is the notification regarding the section 19, my lord.
Publication of declaration.
My lord. People lordships kindly see the section 15, my lord, of new Act 2013.
Hearing of objection.
My lord. Any person interested in any land which has been notified under subsection 1 of section 11 as being required or likely to be required for the public purpose may, within 60 days from the date of publication of the preliminary notification, object to the area and suitability of land proposed to be acquired. B. Justification offered for public purpose. C. The finding of the social impact assessment report. 2. Every objection under subsection 1 shall be made to the collector in writing, and the collector shall give the objector an opportunity of being heard in person or by any person authorized by him in this behalf or by an advocate, and shall, after hearing all such objections and after making such further inquiry, if any, as he thinks necessary, either make a report in respect to the land which has been notified under subsection 1 of section 11, or make different reports in respect of different parcel of such land to the appropriate government.
Now, do you mean to say that this procedure has not at all been followed?
That is only my point.
You take instruction, madam. 15 provision कौची objection देले तार गोटे hearing हबो तापर order टा pass हबो ता से कहउछन जे किसी आमे तो objection देलो आमो किसी hearing हरिया हेइनी जोटा so just take instruction. And if that produce that file also, that would show that the writ petition has been filed by the petitioners challenging the notification under Annexure 5, notification under section 19(1) of the So-and-so Act by Annexure 5. The London Council for the petitioner submits that when by Annexure 3 notification was issued under section 11(1) of the 2013 Act, the petitioners filed their objection under Annexure 4. And section 15 of the 2013 Act clearly stipulates that there should be a hearing of objections. But in the case in hand, the petitioners have not been given any opportunity of hearing and their objections have not been considered and the impugned notification under Annexure 5 has been passed. Stop. Let the Land Council for the state take specific instruction as to whether the procedure as laid down under Section 15 of 2013 Act has been followed or not, and the concerned file we also kept ready out of this matter on 21 तारीख रखिएगा who collector ये जाजपुर 21 तारीख रखिएगा you are getting almost हाँ ठीक है तो 21st April 2025.
Oh, bless. My lord, I beg to pardon, my lord. Item number 13, my lord. I permitted to withdraw and file an appeal, my lord. That I have filed a certified copy. Can I get that
certified copy you want to take back?
अच्छा item number 13 की dictation mention थी by way लिखी देवी ताकि जो certified copy of the impugned order be returned to the Land Council for the petitioner on being substituted with their response.
My lord, Annexure 2 and Annexure 5.
Annexure 2 and 5. These are the two certificates. 2 and 5 portions. है ना data certificate.
Oh, bless.
ये खाली की रखी लो. Certificate.
Other co-appellants have been released.
My lord, one appeal bill matter.
Supplemental list, item number 1.
And when appellant is convicted of under section 302, along with other offences.
कौन है ये?
Appellant is convicted offense under 302 along with other offences and with the fine. Imprisonment life.
For the trial court record. Interim applications for bail and sterilization of fine to be considered after receipt of the trial court record. Deposition copy to be supplied to the Land Council for the state. Yes.
Item 2.
Yeah.
My lord. This petitioner was convicted under section 4.
How many appellants are there?
One appellant, sole appellant.
Sole appellant, why have you filed 2 bail applications?
One bail application is filed to 95 of 2025 laws.
No. One application was pending. Miss case number 1248 of 2014. This is also an application for bail, and this is pending, and you file another one. So you have to withdraw the earlier one, because as it appears that from the very beginning you have got the power. It's not that it's a transfer brief and you came subsequently and filed this application.
Yes.
So your earlier application of 2014, no order has been passed. That is pending.
Yes, sir.
We are putting your question that why have you filed another bail application?
Because you are not, I was not aware about.
अरे आपण फाइल करजंदी अपील आपण फाइल करजंदी मिसकेस आपण कहउजंदी अवेयर ने की अवेयर हो.
So one application
You are to withdraw one application na.
One application I withdraw.
कोटा कहना थी ऑप्शन लाइन पुरानाटा withdraw क्या कहूं
पुरानाटा कोटा
1248 of 1248 at Prague and so on so for bail it application. It file withdraw. Miss case number 1248 of 2014. The Learning Council for the appellant submit that since he has filed a fresh bail application in IA number 295 of 2025, may be permitted to withdraw this miss case. Accordingly, miss case is disposed of as withdrawn. So, how many times you have gone on bail?
Yes, sir. In bail, I have got 3 times on it.
And extended for several times?
Yes, one extended that was, and another also in 2017. So
every
I had
time there is
so
during trial.
You mean to say that your bail application has never been rejected on merit?
Lordship. So last occasion procedure.
Yes.
1/11/2023. 1/11/2023. So I have avoided my application lordship.
1/11/23 rejected.
Yes, that was dismissed or withdrawn for a hearing of the appeal also. That.
Okay. So
during trial also he was on bail fine. Counsel is custody is more than 10 years minor. And also
the allegation that you have killed your wife.
Yes, counsel.
Pouring kerosene.
No, man, kerosene.
Archija now threatening her to pour kerosene. How she died? It's a case of.
What has happened, and she committed suicide. Initially, the FIR was registered minor 498A 304B and 34 and 4 DPF lordship. The charge sheet minor submitted 498A 304B 306 and 406 and 34 of the IPs. Lordship, after that, after submission of the charge sheet, thereafter another IO come and by query of the doctor, the PW2 lordship, and who is the cousin brother of the deceased minor, who had conducted the postmortem lordship of this deceased lordship. And on query, and he submitted this another charge sheet minor, that is 498A 304B and 302 IPs.
No, you also examined some doctors.
Yes, lordship. So I have also examined.
What is the finding of the London trial court?
Yes, lordship.
Which paragraph?
So
what is the nature of death?
12 lordship. The
nature of death.
Yes, lordship. I am reading lordship.
Who paragraph is finding out, you know?
Paragraph 12, the DW2 he has been examined on behalf of me.
No, analysis of the court. Finally,
you come to page number 15, paragraph number 16.
Lordship. Yes. So, DW4 Biranchi Narayan Das is a witness who has stated that the medical officer, DW2, is a relation of the family of the deceased
and as such he is a highly interested witness. But such evidence adduced by the defense through the mouth of DW4 appears to be an afterthought, as no such suggestion in this regard has been given to PW2. Dr. Mutunjay Patnaik, during his cross-examination by the defense, PW2, Dr. Mutunjay Patnaik is a responsible medical officer and he has nothing to gain out of the outcome of the case lawsuit. Even he stood his cross-examination extremely well, and the same has not any material which would be said to be favorable to the defense in any manner. Therefore, from the clear medical evidence adduced by the medical officer PW Dr. Mutunjay Patnaik and from the post-mortem examination report Exhibit 3, it is certain that the deceased Dipti Bala Mohanty died as homicidal death. Now, therefore, it has to be seen whether the accused is the author of such homicidal death of
So this is the finding that it's a case of homicidal
yes,
death.
Lords.
Now, then he discussed that what are the evidence available on record against you on the basis of other evidence, and what are the injuries noticed on the person of the deceased?
Injury Lordship, page 13 of Lordship.
Page 12.
Page 12 Lordship. Para Lordship. PW2 is medical officer. Dr. Mutunjay
Which
Patnaik.
is present all over the body. 2 to 3 numbers of abrasions were noticed on the left side cheek, mandible, so on. So then dissection on internal examination, depression on the wall of right side chest, tears on the right side across function, abdomen was found to be stained with blood, and the screen was injured. So bleeding from the rupture of the brain, finds function. So find that this is asphyxia due to trauma to the vital organs like liver, lungs, spleen. ମାଡ଼ ହେଇଛି ବିଭିନ୍ନ ଶରୀରର ସବୁଆଡେ ଟୁଇଜେସ୍ ରହିଛି, ତା ଦେହରୁ ଗୋଟେ ଦୁଟା ବ୍ଲୁ ପଡିଯାଇଛି, ଏଠୁ ସ୍ପ୍ଲିନ୍ ଆଫେକ୍ଟେଡ ହେଇଛି, ରପଚର କରିଯାଇଛି, ସେଇଥିପାଇଁ ବ୍ଲଡ ଗୁଡାକ ବାହାରି ଆସିଛି abdomen କୁ, and that has resulted in the death.
So far, the DW4 Santosh Kumar Niswal has been examined on behalf of the.
ଆପଣ ଯୋଉ କହୁଛନ୍ତି ସୁଇସାଇଡ କଲା, ଏଟା ତ ଅଲ୍ଟିମେଟଲି ବିଚାର ହବ କଣ ହବ, ସୁଇସାଇଡ ଏସବୁ କେସରେ କେମିତି ହବ, କୋଉ ପ୍ରକାର ସୁଇସାଇଡ କଲା ସିଏ?
The report of the inquest report, so there is a lots there.
No, ଦେହ ସାରା ଏମୁଣ୍ଡୁ ସମୁଣ୍ଡ ଯାଏ ଆପଣଙ୍କର କ୍ଷତ ଚିହ୍ନ ରହିଛି, ଆଉ ସ୍ପ୍ଲିନ୍ ଫ୍ରାକ୍ଚର ହେଇଛି, ଏଇ ଯୋଉ ରପଚର ହେଇଛି, ଏସବୁ କେସ୍ ସୁଇସାଇଡ କେମିତି ହବ? ଏଇଟା
ସେ ତାକୁ କାଟିଲା ବେଳେ ସେ ପଡିଗଲା ଖଟ ଉପରେ,
କାଟିଲା ବେଳେ କୋଉଟା କାଟିଲା ବେଳେ ତ ବେକରେ ଥାନ୍ତା ଦାଗ, where is the ligature mark around the neck? ଯଦି ଆପଣ କହୁଛନ୍ତି ଝୁଲୁଥିଲା, ତାହେଲେ ତ ପ୍ରଥମ oblique shape ରେ ଥାନ୍ତା ligature mark around the neck, ଯୋଉଟା ତ କିଛି ନାହିଁ ନା, ଡକ୍ଟର ଦେଖି ନାହାନ୍ତି.
So but that has not been written, what this inquest report lordship says, inquest was held.
Written ମାନେ କଣ, ସିଏ କଣ ଆପଣଙ୍କ ଶତ୍ରୁ ଯିଏ ପୋଷ୍ଟମର୍ଟମ କରୁଥିଲା?
Inquest report ରେ ଲେଖିଛନ୍ତି ଯେ ଆଜ୍ଞା ବେକରେ ଫାଶୀ ଦାଗ ଥାଇ,
ଲେଖିଲା ଫାଶୀ ଦାଗ।
ଇନକ୍ୱେଷ୍ଟ ରିପୋର୍ଟରେ ଲେଖିଛନ୍ତି ମୂର୍ତ୍ତିଟି ତାର ସ୍ୱାମୀ ସହିତ ପାଟିତୁଣ୍ଡ ହୋଇ ଲୁଗାରେ ଫାଶୀ ଦେଇଥିବା ଯୋଗୁଁ
ଆପଣଙ୍କର ଓପିନିଅନ ଦେଇଛନ୍ତି, ଆପଣ ସେ ଦି ତିନିଟା ସେ ଗାଁ ଲୋକ ବସି ଦେଇଥିବେ, ଲେଖି ଦେଇଥିବେ।
ଇନକ୍ୱେଷ୍ଟ ରିପୋର୍ଟ was conducted by
ଇନକ୍ୱେଷ୍ଟ ରିପୋର୍ଟ କଲମ ନମ୍ବର 9 କଥା କହୁଛନ୍ତି ତ? ସେଇଠି ଲେଖା ହଉଛି, ସେ ସବୁ କେମିତି ଲେଖା ହଉଛି?
କଲମ ନମ୍ବର 8 କଲମ ନମ୍ବର 8, 7
ଗୋଟେ ଅଛି ଓପିନିଅନ ଅଫ ଦି ୱିଟନେସେସ୍ to the cause of death, ଏଇ ସବୁ ଜିନିଷ ଗୁଡାକ। What is its relevance once the PM report finding comes? ଏଗୁଡାକ ସବୁ ଏମିତି ହେଇଥିବ, ସେ ତାର ଡେଥ୍ ଏମିତି ହେଇଛି, ତ these are all just
apparent cause of death can be drawn from the inquest report, but on the face of medical report, it loses its significance.
Yes, Lord.
ତାପରେ ଆପଣଙ୍କ ଲେଖୁଛନ୍ତି ପାରାଗ୍ରାଫ ନମ୍ବର 32 ରେ ଯେ when the fact of homicidal death of the deceased during her stay in her matrimonial home was brought to the notice so and so, no explanation has been offered.
Yes, Lord.
Rather, ଆପଣ କିଛି କହିଲେନି, ଆପଣଙ୍କ ସ୍ତ୍ରୀ ଆପଣଙ୍କ ଘରେ ଥିଲା, ଆପଣଙ୍କ ପାଖରେ ଯେ ହୋମିସାଇଡାଲ ଡେଥ୍ ତାର ହଉଛି, ଆପଣଙ୍କୁ ଏ ବିଷୟରେ ଆକ୍ୟୁଜ ଷ୍ଟେଟମେଣ୍ଟରେ ପଚରାଗଲା, ଆପଣ କିଛି କହିଲେନି, ଏକ୍ସପ୍ଲାନେସନ ଦେଲେନି. So he has taken into account the provision under section 106 of the Evidence Act, your non-explanation, and that apart, there is evidence of the family members relating to the demand and the torture. All these things are also there. The cousin brother, the mother, the brother of the deceased, they have been examined, and all of them have stated that how there was a demand at the marriage and after the marriage also, and how the deceased was subjected to treatment.
All the witness lordship, so they have this relations of the deceased minor. So for the independent witnesses,
ए विषय तो से रिलेशंस माने ही कहिबे झियोटाकू जेतेबेले टॉर्चर हबो ताकू बाडिया पिटा हबो से कोन बाहर लोकन गाय कहबो से कहबो निज मां बापा भाई ए मानको पाखर कहबो तो सेही माने होचंदी बेस्ट विटनेस ए टाइप रो केस रे से माने कहिचंदी जे हमो भौणी बा मो झियो ए टाइप रो कंप्लेंट करथिला और
there is no evidence minor shown before her death that she was being tortured.
So the circumstance of death could have been explained by you, because you were the inmate in the house. Who could be the best witness? So your explanation could have been taken into account.
So that is the other witness, they have stated that, so I was not there at the time of.
You were not there. Clear Pallavi is there.
The defense witness, they have stated lawsuit.
No. Have you seen your accused statement?
Mine.
Accused statement रे सबू तक जहाँ प्रश्न आपन पचराई सबू मिछ कथा आपण किछि ए जो कहउछंती प्ली ऑफ एलिबी आपण नै छंती प्ली ऑफ एलिबी हाउ यू सीन इट
statement sort of there is no, he has not taken.
आपनकर लास्ट क्वेश्चन होची क्वेश्चन नंबर 15.
Yes, lordship.
What have you got to say? मिछ केस सबु बेले
बापा घर
को जीवाकू चाहूतिला घटना दिन से बापा घर को जीवाकू कहला मु मना कली एवं बिल को गली बिलरू फेरी देखली कोन फांसी कथा मिछ in view of the PM report finding आउ जेतिक माड़ सब ताकू हेची से गुड़ाकर एक्सप्लानेशन नाही तेणु ये प्ली रो कोन मूल्य अछि How many years you are in custody?
More than 10 years lost.
केमते आपण पूरा बेल ले थिले ट्रायल ले
बेल ले 6 मास
तापरे गुडाई
6 मास बेल ले थिले
हां lordship just
have you got that custody certificate with you?
He is in custody since 2020 मान
अरे नाही मो जो जाईथिले बेल Where is that custody certificate? Have you got that custody?
That was 5 loss. The custody is long. Since long. So 2020 ଯେତେବେଳେ ଆଜ୍ଞା last payroll ଆଜ୍ଞା ସେତେବେଳେ expire କରି ଯାଇଥିଲା
ସେ ଏ जो ଯେତେବେଳେ କୋଭିଡ ହେଲା ଗୁଡା ଛାଡି ଦେଇଥିଲେ ସେତେବେଳେ so you parole ଯାଉଥିଲେ so you get that instruction about the custody certificate and also instruction about whether anything has been adverse has been reported during the period of interim bail. He has been granted interim bail and it has been extended on number of occasions. Right? 3 times. No? All right. The learned counsel for
there were issues, no?
No.
No,
the learned counsel for the petitioner.
ବାହାଘର ଗୋଟେ ବର୍ଷ 2 ମାସ ହେଲା।
The learned counsel for the petitioner submits that the petitioner was granted interim bail. No, during the period of trial, he was on. During trial, he was granted bail by the learned. He was granted bail, and after conviction, this court has granted him interim bail on 3 occasions. Let the learned counsel for the state produce the custody certificate of the petitioner and also obtain instructions from the concerned IIC regarding the conduct of the petitioner while on interim bail. ଘର ହଉଛି ସିମୁଳିଆ ଥାନା ଅଣ୍ଡରରେ ତେଣୁ ଲେଖନ୍ତୁ IIC of ସିମୁଳିଆ police station ହେଲା matter to be listed 21 ତାରିଖରେ ରଖୁଛୁ ନେଇ ଆସନ୍ତୁ
ମେ ମାସ
21
मेरे
अच्छा मेरे
ମେ ଫାଷ୍ଟ
5/5/2025 ହେଲା and ये जोटा अच्छी मिस केस नंबर 1249 of 2014 इस फाइन रियलाइजेशन टाକୁ स्टे कर देना ହେଲା ये आगुरु अब नहीं थी डिस्कशन मोड एटा नॉट प्रेस ହେଇଥିଲା मिस केस नंबर हां कर देबो ये
Item 3.
Your bail application has been earlier rejected. First time.
Routine bail of 3 months and surrender in time.
No, merit रे केबे रिजेक्ट है नहीं आपनकर
we are not inclined
Four
to,
number
we are not inclined to allow the application.
2 was granted
in
bail
respect
on
to
bail reject है
134 appellant 2 केवल bail
এটা কাହା ପାଇଁ ଫାଇଲ କରିଛନ୍ତି ବର୍ତ୍ତମାନ
appellant number 1, 3 and 4 man.
जोटा rejected 134
134 का केस से रिलेटेड ना
बेटा ये
number
order number 4 3/8 order number 8 3/8/2019 8
that is 5/8/2019 134 ର ରିଜେକ୍ଟ ହେଇଛି 5/8/2019 ତାପରେ ବେଲ ଏମାନଙ୍କୁ ଇଣ୍ଟରିମ୍ ବେଲ ଦିଆ ହେଇଥିଲା କୋଉ ଅର୍ଡର ରେ
item number 58023 23/7/24 appellant number petition number 3.
wait 23/7/24 अच्छा 23/7/24 रे A3 was granted bail. Bail for 3 months. Okay. तापरे अन्य मानु की जाइनी
5/8/24 रे item number 182/9 of 24 रे 184.
5/2020 A1 and
4
A4 granted. They interim bail.
it appears that 1 4 along with appellant number 3 were granted bail as per order dated 21/8/22
Now you have received the copy of the interim application, madam.
Yes, ma'am.
So now he is again claiming for interim bail. So what is the period of detention? And number two, about the conduct when they were granted bail, interim bail. For 3 persons, this bail application has been filed. Appellant number 1, 3, and 4.
It was also in furlough.
Have you got it or you will get it? ଆଣିଛନ୍ତି ନା ଆଣିବେ କହୁନାହାନ୍ତି ସେଗୁଡ଼ା ଦେଖନ୍ତୁ IA number 542 of 2025. There is an application for bail of appellant numbers 1, 3, and 4. The Land Council for the appellant submitted that after the bail application of these 3 petitioners were rejected by this court as per order dated 5/8/2019, appellant 3 was granted bail.
2 was granted bail.
Appellant number 3 was granted bail by order dated 23/7. 23/7 केबे कहले 2024 ना 2024. Appellant number 3 9 S. Bhagavati Dora was granted interim bail for a period of 3 months as per order dated 23/7/2024. And similarly, appellant number 1 and 4 were granted bail by order dated 5/8/2024 in IA number 1829 of 2024. And they have surrendered at white time. Let the Land Council for the state obtain the custody certificate. So also take instruction about the conduct of the these 3 petitioners. Three petitioners filed on interim bail. Put up this matter. 21 तारीख रखना.
Last week of May.
First week.
March. Custody certificate was there 5/7/2024 when my lord granted interim bail. Custody certificate was called for and that was in part of record my lord. 5/7/2024 I am 9 years 9 months from the 11 days.
ଆମେ ତ ଯାହା ବି ହେଲେ ଆମେ କେସ୍ ଟାକୁ ରଖୁଛୁ 5/5 କୁ ତେଣୁ ସେଦିନ ଲାଟେଷ୍ଟ ଟା ପଳେଇ ଆସିବ.
Yes, my lord.
Yes.
Item 4.
4. Yes, Mr.
Last occasion directed to
Obtain instruction.
obtain instruction regarding the status of the daughter of the appellant. The letter has been issued in the month of March, but no response has been received.
ଗୋଟେ ଝିଅ ଥିଲା.
Well, on 13th March, the letter has been issued.
We are also not aware of that.
Outdated.
ଆମେ ବି very about କିଛି ପାଉନୁ
କାହାର
My husband is jail custody. Elder father, mother, one Datak district Mahila committee president.
ସେ ବାହାର କରିବେନି କୋଉଠି IAS ରିପୋର୍ଟ ଆସିଲେ ଜଣା ପଡିବ ଆପଣ ଝିଅ ଅଛି. Land Council probably state seeks some further time to obtain instruction as per the order dated 12/3/2025. Put up this matter. Give a date. Yes.
Item 5.
No together.
Appellant has been convicted under section 272 and
This was issued parents and they have refused to accept. Notice was issued to the parents.
Notice was offered and
Yes.
they refused to accept. What is that? କଣ ମୌଖିକ ନା କଣ?
ନାଇଁ Notice issued to PW7 and PW8. Return answered on their refusal.
report is
21/11 ଏଇଟା ଏବେ ଯାଇଥିବ ଏଟା
ସେଇଟା ତାପରେ ପୁରା ଆମର
କେବେ ଏଟା ଦେଇଛନ୍ତି
22/12/24
ଆସିଛି ଦିଅନ୍ତୁ
ଆପଣ ଏଥିରୁ ଦେଖି ପଢୁଛନ୍ତି
PW7 and PW8 are mother and father of the victim.
ସେଇଥି ନୋଟିସ ଟା ଯୋଉ ରିକ୍ୱାରମେଣ୍ଟ ଅଫ ଲ ଅନୁଯାୟୀ ନୋଟିସ ଯାଇଥିଲା ତାଙ୍କ ପାଖକୁ 376(3) ଅଛି
ଆପଣ ଏଇଟା 22/12/24 ର ପଢୁଛନ୍ତି ଆଦେଶ ମତେ ଅଦ୍ୟ 22/12/24 ସମୟ 9 ଗ୍ରାମରେ ଉପସ୍ଥିତ ନୋଟିସ ଲିଖିତ ବ୍ୟକ୍ତି ଗ୍ରାମର ଭଦ୍ରବର୍ତ୍ତୀ ୱାର୍ଡ ମେମ୍ବରଙ୍କ ଉପସ୍ଥିତିରେ ନୋଟିସ ଜାରି କରିବା କହିବାରେ ନୋଟିସ ନେବାକୁ ମନା କଲେ
22nd. Yes.
Item 7.
Interim bail. On what ground?
No, convicted. Section 302.
Item 7. Driver.
When you are going to
Item number 7.
Paper book.
Item number 7 paper book ready ହେଇଗଲାଣି ପରା ପୁଣି
ନାଇଁ
ନାଇଁ ମାନେ କଣଟା ଦରକାର paper book ଅଛି ପରା have you not got the paper book with you କି ମନା କରୁଛି paper book ହେଲାଣି ଆପଣ ନଉନାହାନ୍ତି paper book is made ready so you are to collect it so and why this application for interim bail has been filed?
He's in custody more than 8 years 7 months. 10/7/2017 he's in custody.
He's a man from Madhya Pradesh.
Yes, man from Madhya
No, I
address was
and there was a direction to verify the address.
Yes.
Have you verified it? ଆପଣଙ୍କ ଗୋଟେ ଦିନର ଟିକେ state against ଯେତିକ case file ହଉଛି ତାର data ନିଅନ୍ତୁ ଆଉ at the instance of the state କେତେଟା case adjourn ହଉଛି ତାର ଗୋଟେ data ନିଅନ୍ତୁ ହେଲା ଏବଂ କେତେ ଜଣ additional government advocate additional standing counsel ଅଛନ୍ତି ତାଙ୍କ ଭାଗରେ କେତେଟା ଲେଖା case ପଡୁଛି ତାର ମଧ୍ୟ data ନିଅନ୍ତୁ ସେଇଥିରୁ ଆପଣ ମାନେ ଜାଣିପାରିବେ ଆପଣ କେତେ କାମ କରୁଛନ୍ତି just keep it in mind ଯାହା instruction ଗଲା କିଛି ଆସିବନି ଗୋଟେ ଲୋକଟା ଫାଇଲ କରିଛି ସେ ହଉଛି ମଧ୍ୟପ୍ରଦେଶର ଆମେ ଆପଣଙ୍କୁ କହିଲୁ ଯେ ଆଣନ୍ତୁ ସେ ଆଡ୍ରେସ ଯୋଉଟା ଅଛି ଠିକ କି ନାହିଁ କାଳେ ଇଏ ହେଇଥିବ ପଳେଇବ କୁଆଡେ ହଁ Superintendent of Police Dhenkanal shall obtain specific instruction from the Superintendent of Police Baitul in the state of Maharashtra. Madhya Pradesh. Specific order is passed and kete thora apun adjournment nebe. So if this much of information you are not able to obtain through your SP, that shows that there is something lacking.
Two months before he had the police cited at IIC also gone to the village, particular village, and taken some instructions.
That's right, but that should come on record. It's not that the Land and Council for the state seeks some further time to obtain the instruction regarding address verification of the petitioner as per order dated 5/2/2025. Needless to say that after the said order, the case has suffered 2 further adjournments. However, the Land Council for the petitioner submits that 1 week further time may be granted to obtain such instruction. List this matter on 22nd of April 2025.
Item 8.
Your Lords, convicted under section 302, efficiency mutation to arrest live, your Lords. He is in custody since 18/8/2019, your Lordship. Next of the case is that in the occurrence date about 5 p.m. the informant was
your bail application was never rejected on merit.
Never rejected, your Lordship.
So, what is the prosecution case?
Prosecution case, your
The offense under 302.
302, your
You come to paragraph number 2 of the judgment. Let us know the prosecution case.
The prosecution case is that on 17/8/2019, informant Balabhadra Barik, son of late Suru Singh Bagh of village
Raipali under Dungri Police Station, lodge a written report at Dungri Police Station. It is stated in the report that on that day in the morning at about 5 a.m. he had been to village pond for taking bath. After taking his bath, while he was returning on the way, he got information that his wife Lakshmi has been murdered by someone. On his reaching, he found the dead body of his wife lying near the well of his bari, and she has been murdered by means of a sharp cutting weapon while she was cleaning the utensil. It is alleged that he has dispute with Balaram Barik, his kaka, Sasur, younger brother of his father-in-law, regarding landed property, who had threatened his wife. This is to put away her life prior to 1 month of the incident. As such, he suspected that Balaram Barik had murdered his wife.
Okay, so is it a case based on direct evidence or
Yes,
circumstantial evidence?
direct evidence. One eyewitness is there, your lordship.
Who is the eyewitness to the occurrence?
PW4, your lordship.
PW4. Mohan Patel.
Yes, your lordship.
कौन କହିଛି ସେ?
The occurrence took place on 17/8/2019 morning in between 5 to 6 a.m. At that time, I was purchasing clothes and found Lakshmi was cleaning utensil near her well. I found accused Balaram gave a tangia blow on the neck of Lakshmi, for which Lakshmi fell down, sustaining bleeding injury. When the accused Balaram was attempting to give second tangia axe blow on Lakshmi, out of fear, I ran away from the spot to the house of my neighbor Gajendra. Seeing my trembling condition, when Gajendra asked me, I told him that the accused Balaram had given a tangia blow on Lakshmi, causing bleeding injury. Out of fear, I remained at the house of Gajendra for about 2 to 4 hours. I was examined by the police.
So anything you have elicited in the cross-examination?
Nothing else.
Nothing. So Bekkare Tangia Chotamalde, who is the doctor?
Doctor is the PW8, your lordship. PW8 also. One part injury, the neck is there. And third blister. Right side. Cause of that, due to throat bleeding, airway obstruction by clothes and normally shocked by sharp object, age of the injury less than 24 hours from the time of the examination.
Conclusion में कहुचंती sharp cut of the neck involving chin, larynx, trachea, muscles of the neck, large vessels also. Obstruction of respiration by pot throat, जोटा कि blood clot करची respiratory passage रे, and then respiratory failure ହେଇची, heart failure ହେଇची, then death ହେଇची. एटा होची report. So how many years you are in custody?
My lordship, custody since 5 years, 7 months, 20 days, your lordship.
9 months already.
That age is 82 years.
82.
82 हमारी
Time देखिए.
At the time of occurrence,
No.
At the time of judgment, 80 years,
Just a
2023 रे.
से गोटे आसची से जो
70
70 years वाला था, अच्छा 80 years.
80 years, 2023 रे थी.
अच्छा आपण accused statement देखियो.
80 years actually.
Accused statement 80 years. So what do you say?
Sir, ये तो final form में कितने थिला? Final form of you नहीं होगा.
हाँ ये अच्छी है. Year of birth लिखा है. Forest ରହୁଛି 75 ବର୍ଷ ଲେଖା ହେଇଛି. That is ତଳକୁ ଅଛି 75. What do you say? ये जो आसची ଏବେ जो ड्राइव आसची दीटा जिनसरे 70 years or above and terminal illness गोटा थिले तांकू नालसार ये अनुଯାୟୀ दबाकू ताकू रिपोर्ट मग ये करंतु तार एज विषय रिपोर्ट दियंतु आ गोटे by the way तार health condition plus any antecedent ये तीनटा aspect रो नहीं आसन हैना. The learned counsel for the petitioner submits that the petitioner is now aged about appeal memo देखें appeal memo 80 अच्छी वाले to 81. The petitioner is now 85 years. As in the impugned judgment which was pronounced around 85 years for them, and his age has been reflected to be 80 years in the impugned judgment. The learned counsel for the state shall obtain instruction on this age aspect also, and also the health condition of the petitioner, so also the criminal antecedent. Tinta aspect put up this matter on 21st of April 2025.
Item 9.
Reshma Behra.
विजयलक्ष्मी त्रिपाठी को मोर मुकदा एक विजयलक्ष्मी किम देवे
नहीं से तो ही परिवहन से हमें we have engaged Reshma Behra.
He is not there. Already informed. Her name is there.
पुणी आवडे चिट्ठी पड़ेगी.
I would put it. Change करो.
हमें इंग्लिश स्कूल के जो रेशमा बेरा को
मैं इंग्लिश स्कूल
रेशमा बेरा can be engaged
by another
for the year. Court order court order अछि 21/2023 से Lexicon it appears that by order dated 21/8/2023, Ms. Resma Behra she college having received the wakalatnama from the applicant.
Yeah, that is directly. Right?
अच्छा किंतु वकालतनामा फाइल करेंगे कि ना
फाइल करने and she was also mentioned. Nine. ओडिशा राज्य आईन सभा अच्छी ओडिशा राज्य आईन सभा प्राधिकरण रे से मागिला सेटा
सरकारी फाइल करे वकालतनामा फाइल कर चंदी on 17/7/23.
Seven. 17/7/8. That's not 19/7/20. 17/7/20. जेल रू आसला
19 डे फाइल करा लिखि दम तले कोन लिखले हां नहीं इनती कर दियंतु it appeared that Resma Behra filed wakalatnama for the appellant, which is dated 19/7/2023. On 20th July 2023, Eshkil Morais, High Court of Orissa. However, a prisoner petition dated 22/24 has been 23/24 has been received to engage Vijayalakshmi Tripathi as his counsel in place of Reshma Behra. Since Vijayalakshmi Tripathi is now in government panel, he cannot conduct the case of the appellant, and let the information in that respect be supplied to the appellant, and further information be sought for from him regarding engagement of the counsel. You obtain that instruction, a free copy of the order. A free copy of the order be handed over to the Land and Council for the state. See, Achi Vartman Senior Superintendent Circle Jail Barampur. Hello? The name of Vijayalakshmi Tripathi shall not be reflected in the cause list henceforth. Hello? Yes.
Item 10.
Mr. Pradhan, Land Council appearing for the appellant, seeks for an adjournment for 1 week. Mr. Parija, Land Council for the informant is present. List this matter in the week commencing from 5/5/2025. Yes.
Item 11.
The appellant been convicted on the section 302 IPC for imprisonment life and fine of 10,000.
You have received the deposition copies are with you.
I have already last
You have given. So come to the paragraph number 2 of the judgment.
It's fine. Prosecution case in brief that on 31/5/2020, the complainant Biranchi Narayan Das appeared in Daspala police station and reported wherein that in the night of 31/5/2020, his daughter Navanita Das and his father were sleeping in the house, and at about 2 a.m., his father woke up hearing the knocking sound of fan and found the victim Navanita has sustained bleeding injury on her head. It is further alleged that his father called his his elder brother Surendra Kumar Das, and both of them took his injured to the Daspala Medical. But due to the serious condition, his doctor was shifted to Noyagarh Hospital, where his daughter died. He also alleged that some unknown person with ill intention entered into his house and has committed murder of his daughter by assaulting me.
So FIR against unknown person.
FIR against unknown person.
Then how you came into picture and what are the role attributed to you?
My lord, I am the here my lord. Brother is the informant. PW1. PW11 is the father of the informant. And I am my lord, younger son of the my lord PW11 and younger brother of PW1. This is the case.
No, that means you are also the brother of the deceased.
Yes. Yes.
You are whom?
Yes.
PW brother of the deceased.
Yes.
Deceased is a girl. And
brother of the deceased, brother of the PW1.
It's my lord, uncle of
Uncle of the deceased.
Acha, uncle of the deceased.
Yes, my lord.
You are the uncle of the deceased. Okay. So eyewitness के यहाँ भी.
Eyewitness to PW11, though an ocular eyewitness, but his evidence is rather doubtful because he immediately immediately stated before the neighbor PW5 and 6 as well as to elder son Surendra, PW10. Thereafter, immediately information was given to PW1. Thereafter, FIR was
FIR unknown actually upon share
yes, my lord.
Is come to the evidence of PW11.
Yes, sir. Subsequent PW11. And also leading to discovery and confessional statement.
PW11 person.
Yes, sir. PW11 Banshidhara Das, my lord. The Bironchi Das is my middle son, and accused person Bipin Bihari Das is my younger son. Nabanita Das, the deceased, is the daughter of Bironchi Das. She is no more. She died about 1.5 years back due to assault by my younger son Bipin. I do not remember the date and year of occurrence, but in the summer season, the occurrence took place. The occurrence took place in my house. My house is consisting of 3 rooms. In one room having one entrance door and one back door. My son Biranchi had gone to Hondagaon at the time of occurrence. In the night of occurrence, I was slept on a cot in the last room of my house. In the said room, my granddaughter was slept on the ground on a mat. At about late night hour, probably 2 a.m. to or 2:30 a.m., I heard beating sound. So I woke up and switched on the light and saw my younger son Bipin Das was beating my granddaughter Navanita on her head by means of a rolling stick and also pulling her towards back door of the house. On seeing me, he left my granddaughter and fled away. At that time, I had seen my granddaughter sustain 2 bleeding injuries on her head. Being my old age, I could not able to take her inside the house. At that time, Nabanita has no sense. So I came out from the house and called my front neighbor Sebati Jena and told the fact. He went to the house of my elder son Surendra Das, who is residing separately from us. After a few minutes, my elder son Surendra Das came to my house and saw the injured Navanita. After that, he came out from the house and called ambulance to take Navanita to the medical. Ambulance came. Navanita was taken to Daspala Medical, where
from she was referred to
DHS Nayagar. But
on the way,
she died. The next day morning, Biranchi Das, father of the Navanita, came to the house as he was not present in the same night due to his business at Hondagaon. I do not know my younger son Bipin Das beating my granddaughter Navanita by means of wooden stick, to which she sustained injury, and at last she succumbed to said injury. I was examined by police in the next day of the occurrence at Dasapala police station, my lord. And so far as my lord cross-examination is concerned, my lord, paragraph 4, my lord, she has stated like this: I have told to my elder son Surendra Das, Birochi Das, and my neighbor Sebakti Jena and others regarding the assault of my younger son Bipin to granddaughter Navadita in the night of occurrence. My lord, immediately Surendra also intimated to my lord the PW1. But all of them has also thereafter, all of them has I along with Bironchi informant had gone to Dasapala police station in the morning on the next day of the occurrence. But my lord, PW11 was also there with while lodging the affair as per so far as evidence cross-examination is concerned. But
no name is there. How can evidence come?
ଆଉ ଏଭିଡେନ୍ସ ଯୋଉ leading to discovery
କଣ?
ସେ ଯୋଉ ଗୋଟେ wooden stick ଟେ ଗୋଟେ
ହୁଁ?
ସେ ଯୋଉ 12 question PW 12 my lord was the witness to the yes my lord
Wooden stick.
yes my lord now by means of wooden stick that was recovered at the instance of from the house.
That has also not been produced before this eyewitness to be identified, and anything was found from that wooden stick on C report. C report mark ही नहीं, C report नहीं है there. C report. C report अच्छी exhibit P24.
Yes, my lord.
24.
And while my lord, police IO my lord, PW my lord, 13 has the cross examination has stated my lord in paragraph my lord 24. It is a fact that the witness PW 11 who has not stated before me that he had seen while the accused pulled the deceased from the last room to the back door of the house the night of occurrence.
L होची से stick टाକୁ L भावरे mark करछन्ति. No blood देखाइछि.
Yes, ma'am. That is chemical
blood and
yes,
substance could not be
that is L no blood.
So you are in custody for how many years?
My lord, from my lord 8/16/2020 my lord.
1/6/2020.
Yes, madam.
From 1/6/2020. विश्वास करता हूँ.
My lord, this that he was talking with my lord one boyfriend so far as allegation leading to discover a confessional statement. ସେ ଗୋଟେ ବୟଫ୍ରେଣ୍ଡ ସାଙ୍ଗେ ସଦାବେଳେ ଗପା କରୁଥିବେ that is the motive. ସେ ବୋଲିକି that is the confessional statement.
The Land Counsel for the petitioner, Land Counsel for the state. The Land Counsel for the petitioner submit that the petitioner is in judicial custody since 1/6/2020. And though PW 11, Bansidhar Das posed himself as an eyewitness to the occurrence and stated to have seen the appellant beating the deceased by means of a rolling wooden stick. But it appears that he disclosed about the same before others, including the informant, and went to Dasapala police station along with the informant on the next day of the occurrence. And the affair was lost at about 9 o'clock on 31/5/2020 against unknown persons. The Mr. Bhansdev Land Counsel for the petitioner submits that if PW 11 was an eyewitness to the occurrence and disclosed the said aspect before the informant and also accompanied the informant to the police station to lodge the FIR, in that event, the name of the appellant would have been there in the first information report. But the lodging of the first information report against unknown person shows that by the time of lodging of the first information report, nobody was aware about the name of the culprit, and the petitioner has been subsequently entangled in the case. It is further argued that the rolling wooden stick, which was the weapon of offense according to PW 11, was seized by the investigating officer and sent for chemical examination, and no blood was found on it, and even the imbue was not produced in the trial court. No, imbue was not shown to the eyewitness bracket PW 11 to get identified. He further submits that detention period, that the petitioner has good chances of success in the appeal, and balance of convenience is in his favor, and therefore the bail application may be favorably considered. Land Counsel for the state, relying on the evidence of the eyewitness as well as the evidence of the doctor bracket रे doctor कितना नंबर सेक्शन PW 14 oppose the prayer for bail. Considering the submission made by the Land Counsel for the respective parties, nature of evidence adduced during trial, absence of the name of the petitioner in the first information report, period of detention in judicial custody, and absence of any chance of early hearing of the appeal in the near future, we are inclined to release the petitioner on bail. Allowed.
Item 12.
May I please?
to seek some time to go through the same. केबे चाहूचंती मैटर आसीबा पई
Next week.
matter listed in the week commencing from 5th of May 2025. Yes.
Item 14.
Right for life matter.
Yeah.
Date of deferment.
Deposition copies available.
Yes, one.
So come to paragraph number 2 of the judgment.
The instant case has been registered on the strength of the affair of dated 5/9/2022, lodged by the son of the deceased PW2, in which it is alleged that on that day at about 12:25 p.m., while returning to his house to take his mobile phone, he witnessed the instant crime and that in his presence, the accused dealt a tangia blow to the backside neck of his mother, nearer to her spinal cord, and that in the evening event of his shouting, the accused had absconded from the spot. Affair further specifically discloses that the accused, being his adjoining neighbor, was frequently quarreling with the deceased, and that as for his previous threatening, he has committed the murder of the deceased. After receiving the affair at about 1:40 p.m., the then IAC Raigada PS registered the same by Raigada PS number 200.
So eyewitness is PW.
PW 200.
PW 2 is the informant.
Informant from eyewitness.
Doctor.
Doctor PW 8.
PW 8.
Bunch of license and rights.
What is the weapon of offense?
Tangia.
Another
Chalk wound ଅଛି ଗୋଟେ ଦିଟା ଗୋଟେ
both injuries were traversely placed.
neck ରେ ଅଛି ପ୍ରଥମଟା deep ଯାଇଛି up to the level of trachea.
Second is also
Esophagus spot, another chalk wound in the neck extending from zygomatic process of this master. Both the injuries victim marchandi.
All the injuries described are antimortem in nature and however cause of death due to injury of the vital vessels.
5 centimeter deep.
An organ of the neck.
Deep injuries.
जोड़े ब्लो ଦେଇଛନ୍ତି 5 सेंटीमीटर ଭିତରକୁ ପଶିଛି ବୁଝିଲେ cause of death is due to hemorrhagic shock part of vital organs of the neck with corresponding organs. ଆଉ এই କେସ୍ ହଉଛି 2022 ର ମାନେ ଏଇ 2-2.5 ବର୍ଷ ଥିବେ କି ନାହିଁ ସନ୍ଦେହ.
Paragraph 10 of the PW8, there is an viscera regarding paragraph 10. As per PW8, the stomach is contents in one jar, portion of liver, spleen, kidney, heart, lung in another jar was kept preserved as a viscera and for future state.
So what is that?
No, how do you overcome the evidence of PW2 coupled with the evidence of PW8, the doctor? And 2 blows have been given on the neck, and the impact of blow, you have seen it. That
PW2 stated in a cross paragraph 6 that I was on the bike when I saw the accused assaulting my mother.
Bike
There is a 2 that
so I could not prevent the accused. He is explaining.
Exactly. They have explained.
That is how he is not able to.
In para 2 and para 6.
There are 2 spot maps that has been prepared, one by scientific officer and another by PW13. And in improved judgment, page number 33, where the improved judgment stated here. Now the question is arises: is it possible for a person to witness the occurrence of the entrance room? In question, if that person will stand in front of the entrance door of the house over 60 road To find out its appropriate answer, the size of the door would be the most relevant fact. The same answer is not available in the spot map. Only there is a
ସେଇଟା spot map ର କଣ ହବ answer?
I came to my house to take mobile. On reaching the house, I saw तार position कोडी थिला, मार position कोडी थिला, केते दूर थिला, जे जो जगह थिला सेटा visible नुहे, ये सब जिनस आपण जे present थिला, जे घटना देखिची, ता जरियारे आनिबे, ना से गुडा spot map रे, the person who has prepared the spot map, he has no knowledge about, so he
PW2 version. PW4 is present in that house. That has been stated here in paragraph 1 of the deposition copy, my lord. I am the informant in this case. The deceased Chandrama Bibor is my mother. The accused Rajesh Kulsika is my neighbor at Puliapada, Rayat Colony. I am a labor by profession. My deceased mother, myself, and Ajit, who is son of my elder brother, we are residing at Puliapada, Rayat Colony on 5/9/2020. I had gone for labor work. My mother and my nephew, Ajit, were in our house. Ajit is also a lover, but on that day, he was at home as he was not feeling not well. So, if my lord,
no, that is, you see that I witnessed the accused coming out from my house holding a tangia. I also saw the dead body of my grandmother was lying on the entrance door of the house in a kneel down position. And there was spot injury on the neck. So this is corroborating the evidence of the eyewitness PW2.
Except that particular spot where he has not seen, rest he is saying.
And after that also, the accused ran away with the axe toward the house of one Dalit himself.
Again, my lord, paragraph 6 of PW2 says stated that on the date of occurrence, I had gone for a labor to clean an area of a private person at Kasturi. Usually, I go for labor work at after 8 a.m. But on that day, I was
You
late.
see, you are not arguing the final hearing of the appeal. You are arguing a bail matter. We have to see that what is the evidence, and PW2 evidence is there, coupled with the evidence of the doctor. So whether the evidence of PW could be acceptable or not, all these things are to be, we cannot give any finding also while adjudicating a bail application. So it is to be decided at the final stage of hearing. But at this moment, the manner in which you have assaulted, 2 blows have been given, and
evidence of
the eyewitness.
PW4 is also present in that house, madam. But PW4 stated
are the learned counsel for the petition, learned counsel for the state, in view of the evidence of the eyewitness PW2 and the evidence of the doctor bracketry PW8, who noticed 2 chop wounds on the neck of the deceased and opined that those injuries are antemortem in nature and cause of death was due to injury to the vital vessels of neck and organ of neck. We are not inclined to release the petition on bail, stands rejected. There is no such application, perhaps it has already been granted. Yes, that has been granted on 10/9/2024. Yes, next.
Item 15.
I have to supply the deposition copy to the
Learned counsel for the petition appellant seeks some time to supply the deposition copies to the learned counsel for the state. Matter will be listed in the week commencing from 5/5/2025. In the meantime, deposition copy be supplied. Yes.
Item 16.
I paid for the adjournment.
Mr. You are Mr. Paridana?
No, my lord, Devidatta Mahapatra.
Mr. Mahapatra, learned counsel for the appellant, seeks for an adjournment. List this matter on 5/5/2025. Yes.
Item 17.
Please, Your Lordship. But I was engaged through a petition filed from the jail.
You have also filed wakalatnama Ajita.
My Lord. After that, my Lord, I have filed wakalatnama.
Yes, yes, right.
It's all right.
6-2.
Period the prisoner's petition at flag A, in which request has been made for engagement of Mr. S.S. Rai as his advocate. Mr. Rai has also filed wakalatnama. The prayer made in the prisoner's petition is accepted, so also the wakalatnama. The name of Ms. Bhakti Shudha Sahu shall not be reflected in the cause list henceforth. Yes.
My Lord, today, my Lord, I will serve a copy of the deposition. Your Lordship may call it on 22nd, my Lord.
The Learned Counsel for the appellant, let the Learned Counsel for the appellant supply the deposition copies of the witnesses to the Learned Counsel for the state, matter to be listed in the week commencing from 21st April 2025. Yes.
Item 18.
My lords, item 18 on behalf of Mr. Mahapatra, my lords. He is in personal difficulties, my lords. I pray the matter will be taken up next week.
Was there. And there are occasion another law concern was there because of taking into consideration the practice. Mr. D.K. Mahapatra was engaged as appointed as coming.
Or D.K. Mahapatra has been engaged as my candidate. His name has been reflected.
Yes, yes, it is.
1/2025.
Okay. A copy of the paper book has also been served. So, madam, what do you want?
My lords, an adjournment next week if it may be taken up, my lords.
All right. Mention is made on behalf of Mr. D.K. Mahapatra for adjournment. List this matter in the week commencing from 5/5/2025. Yes.
Item 19.
Wait, please, Your Lordship. Lordship, we have filed an interim application for bail.
Or what?
So,
Why?
The 1-year death ceremony of mother of the
Kebe.
applicant. Your Lordship, the exact date is not known, but his mother had expired on 21/4/2024. At that time, the
24.
yes, Your Lordship.
Then what is it?
ବର୍ଷିକିଆ ଯୋଉଟା ହବ ଯଦି 21/4 ହେଇଥାଏ ଯେ ତିଥି ଅନୁଯାୟୀ ପଡିଲେ 21/4/24 21/4/24 ହେଲେ ତାର ଡେଥ୍ ସାର୍ଟିଫିକେଟ ଟା ଦେଇଛନ୍ତି
Yes. Your Lordship,
21/4
22/5/24 ହେଲେ ଏତେ ପୁରୀ ପଡିବ
କେବେ ତାଙ୍କ ଘର ଲୋକଙ୍କଠୁ ବୁଝିଲେନି କି କୋଉ ଦିନ
ବୁଝିବାକୁ ଚେଷ୍ଟା କରିଥିଲି, but since like they are not celebrating, it is only that if it comes out.
ସେଲିବ୍ରେଟିଂ କରୁନାହାନ୍ତି ଆପଣ ଯିବେ କଣ ପାଇଁ ଯଦି ମାର ଶ୍ରାଦ୍ଧ ସେରିମନି ହଉନି ଆରେ କିଛି ତ ହଉନି ଘରେ ହଁ ହଉଥାନ୍ତା ପୂଜା ପତ୍ର କିଛି ହଉଥାନ୍ତା ହଁ ବର୍ଷିକିଆରେ ଯୋଉ ହୁଏ ଶ୍ରାଦ୍ଧରେ ସେଗୁଡା ଯଦି ହଁ ହଉଥାନ୍ତା ଆପଣ ୟୁ ଆର୍ ଦି ସନ୍ ଓ ଆପଣଙ୍କ ପ୍ରେଜେନ୍ସ ସହିତ ହେଇଥାନ୍ତା କିନ୍ତୁ ଯଦି କିଛି ହଉନି ବୋଲି ଇନଫର୍ମେସନ ପାଇଛନ୍ତି ଆଉ କାହିଁକି ଯିବେ ବୁଲିକିନା ଆସିବେ ନା
Keep it to tomorrow. I'll ascertain what is the exact date.
Please, this matter tomorrow as prayed for. Yes.
Much obliged.
Item 20.
Yes, Mr. Paul.
This is for bail, my lord. The circumstantial evidence. The only post occurrence witness is his daughter. The husband has, it is alleged that the husband, the wife was sleeping together and the daughter was there. While she has gone to attend the nature call, she came back and saw that her mother is lying dead. when she asked her father.
Watch for a moment.
Huh?
This is assigned to Mr. P.S. Naik because of person. May I pray for tomorrow?
କିଛି ଅସୁବିଧା ନାହିଁ.
Tomorrow.
Mr. Pal, you are available tomorrow? All right. Tomorrow. As prayed for by the learning council for the state.